Good morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan. I will be your guide on this journey through Courtlandia for the next 4 hours. Let's get our day started in Lansing, Michigan. This is Judge Buchanan.
FY.
Good morning, Your Honor. Natalie Maycomb on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Kenneth, Benn, also present by way of video conferencing.
All right, and you did confirm that you are Kenneth Benn on the video, is that right?
Yes, ma'am.
Thank you. Today's the date scheduled for probable cause conference. We have a preliminary exam scheduled for next week on April 2nd. Have we decided what we're doing?
Yeah, it's my understanding that we will be proceeding to the preliminary examination next week. The people do have a small request of the court. I hope it's a small request. In speaking with the victim in this case, he's requesting that either his appearance not be mandatory until 3 p.m. or we not begin the prelim at 3 p.m. And his reasoning, Your Honor, is because of his work schedule. While he has a subpoena and his work is required to provide him the time off, he's due to other cases that his children are involved in, one his child being a victim and one his child being a defendant. He has taken a lot of time off of work and is afraid that there may be other repercussions if he has to miss work to come to this exam. He is willing to come to the exam. He has been participating in prosecution. He's just requesting that instead of starting at 1:30, we start at 3, or at least his presence can be here at 3.
Mr. Feigelson, do you wish to be heard on the request?
Judge, I'll leave it to the court. I understand Ms. Maycomber's position. We'll leave it to the court because it's possible we could always start, and by the time he gets here, it'd be 3 o'clock anyway, so leave it to the court.
Yeah, I'm looking at my exam docket for that day in the afternoon, and I have a full 10 exams.
Yes.
So I'm sure we'll have plenty to work on until his arrival.
Okay, thank you, Judge.
Okay. Anything else, Mr. Feigelson, for the record?
Nothing today, Your Honor. We'll just leave it on for an exam.
Okay, we'll leave this on for preliminary exam. Mr. Benn, you have a no contact order that applies whether you're in jail or out of jail. Remember that, because if you use the jail phone to make calls, the prosecutor can listen to your calls. They can use your calls against you. They can use your calls to add additional criminal charges. You could also be in contempt of court and face up to 93 days in jail and or $7,500 in fines consecutive to that which you already face. Understand?
Yes, ma'am.
All right, then we will conclude with Mr. Benn. Thank you.
Mr. Benn, I'll talk to you next week, okay?
I guess I'll put you in the visiting room because.
While she racks up the next contestant, good morning once again, everybody. Ashley, thank you for the $10 super chat. Tim, thank you for gifting 5 memberships. Appreciate that. So an explanation of the super chat goal that I set for today. If we hit 10 super chats during Monday's 4th hour, I will do a photo show of all of the pets of TCF. And that's not just the ones we have here at the bunker. I will allow you to email in pictures of your pets as well, and we will share them all because I know we all love our animals here. So that will be what will happen with the 4th hour on Monday if we hit our goal, just so we're all clear on that. Let's get back to Judge.
As the interpreter.
I think he's at the facility in Baldwin, Ms. McRae.
Oh, is that where it is? Okay. This is my phone. People would just respond to you in the chat. That would be helpful.
Hello?
And
I'm the interpreter.
yeah, and you're interrupting the court. Please don't do that. On the record in state of Michigan versus Elmer, Andino, Ramirez, 2600606 FY.
Andrea McRae appearing on behalf of the people.
Good morning, Your Honor. Again, Assistant Public Defender Stephen Feigelson on behalf of Mr. Andino Ramirez, Your Honor. He is not present. My understanding is at the ICE facility up in Baldwin, Michigan, Your Honor.
Correct. So we do have an interpreter here today, but I didn't ask her to be sworn in or anything yet because we don't have the defendant for the interpretation. I guess, what information do we have to confirm that he's detained? He appears to be logging into Zoom right now. So do we really think he's detained?
No way. Oh, I think he's detained.
Well, are they logging in from the detention center?
That's awesome if they are. Oh, it might be the family.
I don't know. If you are Elmer Andino Ramirez, you need to unmute and identify yourself. Oh, all right. Well, Ms. Nickel, you may have someone to interpret for. Is that your client, Mr. Feigelson?
I believe so, Your Honor, but can,
You gotta unmute there, Ms. Nickel. Sandra, please unmute.
The name that I have is Elmer. Is this the same person? Elmer Regalado?
We have Elmer Andino Ramirez.
The name I'm here for is Elmer Salvador Regalado. I may
No,
have the
that
wrong
was-
client.
Salvador Regalado was a gentleman we saw yesterday with a different last name. The person we need you for today is Elmer. I see they typed it wrong. I see it right here on the document. It's supposed to be Elmer Andino Ramirez.
Okay,
Okay, Mr. Feigelson, I'm assuming you have not spoken to your client since you believed he was unavailable to you.
that's correct, Your Honor, I have not.
Would you like a breakout room with your client and the interpreter?
Yes, please, Your Honor, thank you.
Okay, I'm going to try and put you all together. Sandra, if you can tell Elmer, he's gonna have to click join when the prompt appears on his screen.
don Elmer, mi nombre es Sandra Nickel y va a tener que poner unirse, que se llama Join, Join, cuando usted lo mire en la pantalla, porque nos van a poner en un lugar donde solo esté su abogado, yo y usted, ¿ok?
Ok, ya me apareció, ¿lo puedo clicar?
I already see it. May I press it? Sí, correcto.
Right.
Sandra, please join as well.
Okay.
Well, that was a weird turn of events. We didn't know they were going to be available.
Now we're gonna get it all set for next week for all the interpreters and they won't bring them.
Well, I don't know where he is, so that's gonna be the first question is, where are you?
Not sure if he'll be there even after Monday.
I don't know. I don't
Nice.
know. I don't see anyone in that visit room.
Okie dokie, friends. The courts are off to a little bit of a slow start this morning, as is Judge Buchanan's court in and of itself from the looks of things. However, we do have Judge Elmore. Looks like he's about to do something, so let's go up there and say good morning to him.
Stapleton, do you have the old PSI for this file?
Yes, sir.
Mr. Burke, if you can hear us. There he is, everybody.
Good morning, Your Honor. Sorry about that.
It's okay. All right, we are now on the record today on this Friday, March 27th, Going on the record now for the 28th Circuit Court here in Wexford County. Our first file this morning is People of the State of Michigan versus Henry Collins. The file number in this case is 19-12592-FH. Appearances, please.
Your Honor, good morning. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office, appearing for the people.
Thank you, Honor. Taylor and Anna Corvento on behalf of Mr. Collins, who's present in the courtroom.
Thank you. All right. Also this morning is Mr. Kevin Stepleton. He is the agent today, who has been the probation agent on this case since it began back in 2019. He is here before the court. And we're here today for a probation violation hearing. Let me take a quick look here at the history of the file. Looks like we were last here on the record last week on March 20th. That's Friday. Defendant requested a hearing to be conducted within 14 days. Bond was denied. He was remanded into custody. Looks like that was actually the informal hearing, the second hearing after we conducted an arraignment on March 17th. So we're here today for a formal hearing. All right, Mr. Burke, have you had the opportunity to speak with, you know what, I don't like it when I say, have you had the opportunity? Everybody has had the opportunity. Have you actually spoken with the prosecutor? I'm sorry, the defense attorney on the file.
Your Honor, counsel and I spoke last week in a breakout room, and we talked about a couple different options. I'm not quite sure exactly what the defendant's position is today, but I did speak with counsel last week about, like I said, a few different possible options to resolve this.
All right, so what are the answers? Mr. Arvento?
Thank you, Your Honor. Today, my client would be prepared to move forward on a plea to the offer extended last week by the prosecutor, and I have met with my client in this since our last hearing. We met at the jail. We met again this morning. Sorry, the radiator is quite loud.
That's all right. Keep going. So what's he going to do? What's he pleading to?
Well, Your Honor, we would like to plead guilty to count 1 and count 4, which was the allegation that my client was convicted of new offenses in the state of Oklahoma. We ran into an issue this morning, though, talking to Mr. Stibleton, is we are not sure if the records Mr. Stibleton has would be sufficient for purposes of that or with the court. And I would like to be able to talk to the prosecutor about that, or ask the court how they'd like to proceed on that issue.
So, one moment. So there were a total of 4 counts. The original alleged violation was filed in this file on January 13th of 2001, alleging that on November 6, 2020, the defendant had violated a criminal law of a government, specifically the government in Oklahoma, for a case of child neglect. That's one of them to which he would plead. Count 2 and 3 are that he failed in effect to report from January and February of 2021 for a period of more than 60 days. Therefore, there would be an absconder status. And then count 4 is the violation for count 1. I'm sorry, rule 1 again for violating another law. That one was possession of methamphetamine in the state of Oklahoma back on October 21st of 2020. I don't understand here. I'm going to boil it down this way. He's willing to plead guilty to 2 out of 4. All 4 are non-technical, which means whether he pleads to 1 and 4, 2 and 3, or any combination thereof, it's the same result. Mr. Arvento, what does your client wish to do? To which ones are you going to plead? And he's going to make the statement that he knows whether or not he was convicted or not convicted. He also knows whether or not he has or hasn't had any contact in 5 years.
If the court will allow him to just testify that he was convicted in Oklahoma and that testimony is enough, then we would want to proceed forward, pleading guilty to count 1 and count 4.
All right, got it.
Thank you.
Mr. Burke, are you okay with that?
Yeah, the people would be satisfied with the defendant offering an acknowledgement as far as like the factual basis for the plea. That's fine, Your Honor. Yes.
Thank you. Mr. Collins, is that what you want to do today?
Yes, sir.
All right, to the best you can, please raise your right hand for me. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. All right, Mr. Collins, I covered a little bit just briefly there a moment ago what the 4 counts are, and I covered them last week. Do you need me to repeat them to you?
No, sir.
Now, by pleading guilty to count 1 and 4, which again are the allegations that you were convicted of a child neglect in Oklahoma and convicted of possession of methamphetamine in Oklahoma, you're not going to have a contested hearing. You'll be waiving the right to question or cross-examine any witnesses against you. You'll be given up the right to be presumed innocent until the prosecutor proved beyond or by a preponderance of the evidence that you were guilty of those. You'll also be given up the right to confront those witnesses, present witnesses, evidence for testimony yourself. Plus, you'll be given up the right to remain silent and the right to not have that silence used against you. Do you understand?
Yes, sir.
And once again, because in this original case, you were convicted of failing to pay child support, you would, if you are found guilty or I accept those pleas, you'll be facing resentencing on the original offense, which is a felony punishable by up to 4 years. Do you understand?
Yes, sir.
And has anyone made any other promises, threats, or inducements that we haven't talked about this morning on the record to get you to enter this plea?
No, sir.
Are you making the plea of your own free choice?
Yes, sir.
All right. Now, there is one more thing I realized I failed to mention to you. I know there was an extradition to help move you from Oklahoma out here to the great state of Michigan, and probably what is the best time of year to be here and to probably be inside. But anyways, you could also be reassessed that cost for that extradition fee. Do you understand?
Yes, sir.
All right. Knowing all that, do you still wish to enter the plea of guilty as we discussed?
Yes, sir.
As to count 1 of the requested warrant for probation violation, which again asserts that you violated condition 1, not to violate any criminal law of any unit of government, and that specifically it's based upon a finding of guilt for a case of child neglect out in Oklahoma. How do you plead?
Guilty, Your Honor.
And as to the count 4, again, violating the same rule or condition number 1, not to violate any criminal law of any unit of government, that one applies to that you pled guilty to the possession of methamphetamine in Oklahoma. How do you plead?
Guilty, Your Honor.
Mr. Collins, first, the court takes judicial notice of the terms and conditions of probation that are contained in this file, and they were issued by my predecessor, the Honorable Judge William Fagerman, and was then subsequently signed and acknowledged by the defendant. Judge Fagerman signed it on October 29th of 2019. Mr. Collins signed it, looks like on exactly the same day. Sir, is it true that back in, hold on, I gotta find the right date, just a second. Back in Oklahoma, on or about November 6th of 2020, you were convicted of a charge of child neglect, which is a criminal statute?
Yes.
All right, and did you enter a plea to that, or was there?
Yes.
Okay, and how did you plead?
I pled guilty.
All right, and sir, is it also true that subsequently, on or about October 21st of 2020, you pled guilty to a charge of possession of methamphetamine, a criminal statute in Oklahoma?
Yes.
And again, you pled guilty to
Yes, sir.
admit to that. All right, thank you. Mr. Burke, you believe he's provided a factual basis?
The people are satisfied, Judge. Yes, thank you.
Are you aware of any other promises, threats, or inducements?
None for the people, Your Honor. Thank you.
So far, do you believe that I've complied with Court Rule 6.445?
And the people are satisfied, Your Honor. Yes, thank you.
Thank you. Ms. Fiorvento, do you agree with all three?
Yes, Your Honor.
Great. The court agrees as well. I find that the plea today has been made freely, knowingly, and voluntarily. I further find that the testimony provided by the defendant under oath on the record, in addition to the judicial notice of the terms and conditions of probation, that the defendant is guilty of counts 1 and count 2 on the 2 requested warrant for probation violations. Counts 2 and 3 are therefore dismissed. Mr. Stapleton, can we proceed with the sentencing?
We can, Your Honor.
Mr. Burke, any objection to that?
No objection, Your Honor. Thank you.
Ms. Fiorvento, any objection? Keep in mind that if we did sentencing today, that means I'm not ordering an update, which means prison isn't going to happen.
We would like to proceed forward with sentencing today, Your Honor.
Great, thank you. All right, Mr. Stapleton, let's go over your recommendations.
Thank you, Your Honor. The defendant was originally sentenced October 28, 2019, to a 2-year probation term. He had 150 days jail with 110 days credit. He was immediately transferred to Oklahoma, which is where the state which he was extradited from for this case of child support. He was supervised in Oklahoma. He was obviously violated probation on a couple different occasions, then absconded from probation supervision for a number of years, and here he is here before the court today. According to my calculations, he has 127 days credit. That's the time that he was
Actually sat, not good conduct time, but
no, not including good time. No, I'm sorry. That would be without good time.
yes, what I meant. I'm
Yeah.
sorry. Keep going. Let's stop talking, you and I. You just keep going yourself. You're doing a better job than I am.
Anyway, it'd be my recommendation that probation be revoked. The defendant be sentenced to a lengthy term of jail. All fines and costs preserved, and as well as child support. There's also a restitution request from the state of Michigan for this recent extradition, which is $4,108 even.
That's it.
That's it, yes, sir.
Mr. Burke, on behalf of the people, sir, allocution.
So, Your Honor, the couple things I want to point out. The defendant's current arrearage as of this month is $64,328.43. The good news is the defendant does not have an ongoing support obligation, so it's not growing, but it's still north of 64,000. The as Agent Stapleton indicated, sentencing was on October 28th of 2019. Since that date, there's been one reported payment towards child support, which was $70 on February 6th of 2020, and that's it. No other payments. So before that, the latest reported payment before that February of 2020 payment was in June of 2019, before the defendant even took a plea. So I mean, it's naturally the idea of these cases is to have the defendant support his or her child or children, and the defendant took a plea back in September 2019, sentenced in October 2019, and he's made one payment since then, the amount of $70, and he's picked up 2 criminal convictions. The arrearage is north of $64,000. As far as the sentence is concerned, Your Honor, I'll leave it to the court's discretion, but I wanted to make sure the court was aware of those figures and that information.
Ms. Fiorvento.
Thank you, Your Honor. My client would respect the request to be allowed the opportunity to try again, and he understands that some period of jail might be necessary, but he has been working to improve things. He's reported to me, he's communicated with his wife. They have figured out a monthly budget and to begin making regular payments on these arrears. He reports that he had some job prospects and he was starting to kind of get things more stable and get back on his feet. He reports that while he didn't report formally sometime in 2025, he started trying to make phone calls to find the right person in Michigan who he could then start making payments to, but he wasn't really sure where to go or who to talk to. He is remorseful. The court has sent a very clear message being picked up and extradited that this is not something that can be ran from. This is not something that can be avoided. This is something that needs to be tended to until all of this is taken care of. And if he was to run again, it would lead to more arrearage, it would lead to more extradition. It would simply make the situation worse. For that reason, Your Honor, we do respectfully request that he be allowed another opportunity at probation, or that any additional time be kept as minimal as possible, kept in county, and that he be able to somehow get back to working as soon as possible. Thank you.
All right, Mr. Collins, you have the right to make a statement if you choose to do so. Anything you wish to say, and you may remain seated, whatever's most comfortable for you.
Yes, Your Honor, I know I screwed up.
Uh-huh.
60 years old. I don't want to live like this no more.
What do you mean by that? Living like what?
Running, hiding.
On your last PSI, you had a job and that's why you moved to Oklahoma. You had met your wife in Texas.
I got a new life.
A new wife?
Yes, the wife I had before is the reason I got the meth charge, so I got a new wife now.
Okay,
I've been divorced and married since then.
all right. So
I
what
got
have
a
you been
good one
doing?
this time.
Yeah, what have you been doing? You also had a child out. Let's do it this way.
Yes,
You also had a
I
child out.
I had a new child, yes.
All right,
Now I got a new grandchild.
okay. All right, so what else have you been doing? I mean, working. Tell me about your work schedule. Last time you were working as a fry cook someplace.
Sonic, yes.
Okay, all right.
And after that, I started working as a maintenance guy at a mobile home place, RV place.
All right,
And I was basically working for my rent then.
okay.
And that's when I got picked up at.
How long you been married this next time?
We got married in the 21st, on 2021. August 16th, 2021.
Anything else, sir?
I'm sorry. I
Well, you don't need
I was
to,
stupid.
you don't need to say sorry to me. This
Right,
is,
I understand.
yeah, I'm just the judge. I just sit here
You're doing your job.
5 days a week and I wasn't even the judge when the case began. All right. Well, this is concerning. Let's be quite here. I don't know what the defendant's criminal history has been since, other than the 2 charges we've talked about. So his criminal history was actually relatively low, at least back in 2019. There was only a string of some misdemeanors. In 2009, there was a meth conviction. Looks like that may have been in I don't know which county that was in.
That was in Cook County, Texas, Your Honor.
Yep, there we go. I see. We also had another case out in Cook County, Texas, in 95. Well, under the influence of 95, and clearly all those would, if he was being sentenced today, those, well, actually, no, there would not be a 10-year gap, but still. All right, well, the big problem here is, Mr. Collins, you haven't made any real effort to make these payments, and it's really easy, and I'm not trying to pick on the attorney, but it's very easy for me to pick on some of the things she said. Why? We've had no progress, and not knowing how to change and find phone numbers and what to do. Mr. Stapleton was the probation officer when this case was sentenced. Mr. Stapleton, you worked at that in the same office, the same physical spot in this building for how long?
9 years, Your Honor.
Consistently. You didn't disappear for a year and go someplace.
No, Your Honor.
No. You got the same phone numbers, you have the same office space. Yeah, you didn't try hard enough. Plus, this courthouse has been here for 111 years. And while I'm sure it didn't have the same phone number 111 years ago, we still have the same courtroom, the same phone numbers. My predecessor and sat in the same office. Phone numbers for the courthouse haven't changed in decades. So, yeah, you didn't make any effort to make these payments. And you don't need to apologize to me. I'm not the child who didn't get the $64,000 or the spouse who did not get the $64,000. So, plus there was a word that you stated that completely contradicted your attorney. I don't want to live like this because I no longer want to be on the run. Contradicts Ms. Veravento's statement that you were trying to find the right phone number, which of course is on the internet.
I was
Yeah.
trying to find for Attorney General. I found it. I was waiting on a case number.
Well, all you needed to do was call this
Yes, sir.
court,
Yes, sir.
call your probation officer.
Yes, sir.
Yeah, that's the person you should have been talking to. Why? Because my predecessor told you to keep talking to that guy, but you stopped communicating with that guy 5-6 years ago. So, no. So now we're at a point, the child is well over the age of 18. You haven't made any payments. 60 years of age. Yeah, I say you haven't made any. Yep, I know there was like one payment made. And it cost the government $4,100 to bring you from the great state of Oklahoma. Having been stationed at Fort Sill, I can tell you that the word great is in parentheses, especially in June and July. But anyways.
Or August, yes.
Yeah, in August. So anyways, the sentence of the court is as follows. The court terminates probation without improvement. The court preserves all fines and costs, plus the court needs to add to that, Samantha, $4,108 for extradition fees. That's payable to the state of Michigan. And then as for a period of sentence, well, the court looks here at the previous guideline range, which was 0 to 9 months, which we know is an intermediate sanction cell. And the court to be able to give any period of confinement, even though confinement was given by Judge Fagerman back before there were the changes in the law defining what can be done for intermediate sanctions. The court also finds that there are reasonable grounds based upon the continued failure to pay years, failing to comply with probation, committing new criminal activity. Therefore, the court finds reasonable grounds, and that the reasonable proportionate sentence will be that the defendant is sentenced to a period of jail in the Wexford County Jail for 365 days with 127 days of credit. The court considers that while I do recognize that this is about a defendant who may or may not have been able to pay, but it sounds like he's had jobs, and so he's had some ability to make some payments. But even more importantly, the court considers deterrence. We get a lot of child support cases here, and the Attorney General's office and the Public Defender's office do pretty good jobs making opportunities available for people to get reduced charges. And so the deterrence has to be here, and that greatly outweighs allowing time for payment. The message needs to be sent by this court. If you are unable to engage in sexual penetration and produce a child, you need to be able to take care of that child. That's the sentence of the court. Any questions, Mr. Burke?
Your Honor, you indicated that all costs and fines or fees are preserved. Does that include restitution?
I did, including restitution for his pay. Samantha, I need 2 appellate forms, please.
And then, Your Honor, do you need that number again? The balance for any kind of
60
paperwork?
Yeah, hold on, Samantha, write this down. The arrears are $64,328.43. Did I get that correct, Mr. Burke?
That's correct, and that's in addition to the extradition cost of the $4,108. Thank you, Your Honor.
Yep. Copy that. All right. Samantha, once you grab those two forms, you can take a moment while you're doing that. Mr. Stapleton, here is the old PSI. I'm returning it back to you. You have it over there?
Getting the duck bill, so.
Okay. Mr. Burke, Samantha's computer is spinning around. Therefore, I'm going to direct, if you could please pick your favorite song from Sesame Street and sing it for us. Ready? No,
You want me to do that, Your Honor?
no, not really.
I don't want to offend anybody.
I know. I appreciate that. One moment. All right. Mr. Collins, Miss Samantha is going to bring to you and provide to you through your attorney 2 copies of one document. You are to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the other copy of the same document, which you'll take with you. Now, this document tells you that you have the right to appeal the conviction and sentence in your case, and that is typically done by filing a claim of right to appeal. However, based upon the pleas in this case, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return it to the court within 42 days. Thank you very much. We are adjourned.
Thank you very much. And Mr. Stapleton, thank you. And Mr. Ferret, thank you. Have a good weekend, Aaron.
So I am totally in agreement that if you have child support, you should pay it. But I've said it before and I'll say it again. I also think it should be 100% incumbent and required, honestly, on the part of the custodial parent to account for how that money is spent. And there is no jurisdiction that I am aware of where the custodial parent is held accountable. And I think that is a travesty of justice. I don't know if that applies in this case or not, but I think it should happen. Anyways, good morning once again, everybody. TCF Live on a Super Friday. Speaking of Super Friday, our Super Chat goal today, if we hit 10 Super Chats on Monday during the 4th hour, we will do a photo show with the pets of TCF. That includes yours as well if you send me photos. So let's try to hit that goal today because I'd love to do that. Speaking of which, Tim, thank you for your gifted membership. Lindsay, thank you for gifting 10. Ashley, thank you for gifting 5. And Grandma TCF, thank you for your $10 Super Chat. I appreciate all of you. Thank you so much. Let's go to Huron County, Michigan, Judge Prill. So this is the case of Brittany versus Carrie. So we've got 2 ladies going at each other about something. Let's see what this is all about.
Bazan, file number 26208178PH. This is the petitioner, Ms. Woodwright's motion to seek a personal protection order. She's in the courtroom. She's in pro se. Ms. Bazan also appears in the courtroom. She's also in pro se. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God? Yes.
Thank you. For purposes of history in this matter, Ms. Woodwright filed an ex parte motion seeking a personal protection order against the respondent. That was on March 16, 2026. The court reviewed that petition the very same day and issued an order the very same day denying the petition for personal protection order, stating that the petition is not clear relative to 2 alleged unconsented contacts. When it appears some of the allegations involve the petitioner's minor children, petitioner may request a hearing if she wishes to, with notice to the respondent. It is the petitioner's burden to seek a personal protection order by preponderance of the evidence. And so the burden rests with you, Miss. What is the reason you're requesting a personal protection order?
Your Honor, it has been an ongoing situation that The respondent has been using slurs against my disability. She has been screaming and cursing for children playing in a commons area upstairs in our own level apartment. She has come out and produced a cell phone and recorded myself and my children while she has blocked off the entrance and the stairwell that is the only entrance and exit in the building, while she proceeded to insult me and use discriminating comments. And then she then proceeded to return to her home when I made a police report that same day. It is in the massive stack of evidence. She continues to post on her social media in regards to myself, my mental health, my disability, my whereabouts, my ins, my outs. When I'm doing something, even carrying my child up the stairs, saying I'm not disabled enough to be doing that. It is insulting to myself. It is insulting to my children to be mentioned on her personal public Facebook page. And she has even gone as far as, unfortunately, going to the police department and telling them words that did not get said and using an image that she had requested over a year ago or 6 months ago in lieu of it being where I was at the bus stop waiting for my children, and I had seen the Seaboing chief's wife. She had then made derogatory remarks against me towards the chief's wife, which then caused a stir with me and the chief of police. It caused an emotional distress, causing.
So she allegedly made statements about the chief's wife that made a problem with you?
She said it was me. She said I said something in the matters of his wife reporting for booty duty at somebody's house. And that was not said. And it was a vague picture to show where the house was, because she said, which house is it? And I sent a vague picture. And this was over 6 months ago. And the chief then responded in upset, and that is understandable, but it caused me grave emotional distress, which caused anxiety, hyperventilation, to the point of being extremely ill, to the point of almost blacking out and needing emergency service from my caretaker. And I was on bed rest for the rest of the day.
So, I mean, I reviewed the initial items you had submitted to the court for the determination whether to issue an ex parte personal protection order. And then in this motion, I mean, there are just pages and pages and then comments. I mean, that
I apologize for the comments.
well, it's impossible for the court to understand what this is about. Now, mind you, I don't know if this is hearsay or not. I have no idea, but I need to have firsthand observations by you to indicate 2 or more unconsented alleged stalking type of situations, which would warrant a personal protection order. But your original request was from, you even mentioned over 6 months ago, correct?
No, Your Honor. This is really confusing, and I had hoped that we had gone last, because it's a lot, and I know you like short and sweet, but
That's not true.
There's no short
Excuse
to
me,
this.
miss, short and sweet. Oh, no. If you wanted to see short and sweet, you should have seen my predecessor, whom I highly respect. My predecessor, the Honorable M. Richard Knobloch, it would be more than quick. I allow, and I'm not saying he never did, but I allow the parties the opportunity to speak. And I even asked them again, is there anything else? I do that for a reason, because you are entitled to have a hearing and to bring all this information out. But I take umbrage with that statement that the court looked short and sweet. That's not how we work.
Well, I meant that in no disrespect.
And I'm not taking it that way, but I want to make sure you understand that's where we stand here. But I do recall, though, in your request, originally, You referenced June 2025.
Yes, that is when this whole matter had started, the end of our friendship, Your Honor.
Oh, there's a friendship.
There was a prior friendship.
Okay, that's fine.
That is all. I wanted to get the whole truth and nothing but what happened. I have a timeline and it is an outstanding 10 pages long. And it is just a lot of her posting on social media in correlation to what she has never brought to me personally without screaming and cursing at my children first.
Are you alleging it's slanderous?
I am.
There are other causes of action which I can't get into, but how does that apply toward a personal protection order regarding stalking?
Your Honor, she has mentioned, and it is my apologies. I'm just going right here and read it from her own post. Again, I apologize for the delay and everything else. I am quoting her own personal Facebook page. She makes a comment that she simply said, someone who claims to have PTSD sure causes a lot of stress and everyone in the building. If she would stay out of the hallway and stop yelling at everyone or allowing her children to play board games in the hallway, there would be less noise and there would be no complaints. As it is listed in our lease that a commons area is not a playground. If she claims to have such a disability, she can sure climb stairs, stand in the hallway, making up her own stories and speaking Spanish off of the top of her railing to us. I watched her carry groceries up the stairs. I watched her carry a baby up the stairs. She claims that she's been in bed. She claims that her doctor told her my stress is causing her complications. There is no need for someone to be watching the ins and outs of anybody who is coming into the building, especially when making derogatory statements about someone's disability, to tell me or tell her whole Facebook that she is watching me go up my stairs, go down my stairs, carrying my child.
And I'm not trying to be cute or coy with this, but does it ever mention your name?
She posts my personal Facebook page that has my name on her Facebook.
No, I asked whether or not these posts list your name on it.
No, but I am the upstairs neighbor that she insinuates, sir. Because she says in her Facebook as well, that every other neighbor in our building is cool and it's just her. And she only yells at my children and only causes issues and disturbance between me, even if everybody else is out of their apartment with us.
So I clearly noticed Chief Repke is here, Chief of Police, Sebring Police Department. I'm assuming you've called him regarding these allegations, correct?
He first came towards me with.
No, I asked a question. Have you called him regarding these allegations?
I have not called him.
Why not?
I have called Sebring Police, but not him personally.
Oh, I'm sorry. Well, my question was too specific then. Did you call law enforcement complaining of these allegations?
I certainly did, sir. And
Okay.
then they.
And was the Sebring Police Department sent out?
The Sebring Police Department had made a call towards me and said, just make a note of it if you have a notebook.
Did you reach out? Because it appears that, and I'm looking at one of your pages here, This was a complaint form to the apartment complex, and it references Sheriff's Department. The tenant of A9 was served PPO paperwork by the Huron County Sheriff's Department. So has the Sheriff's Department been involved as well?
Yes, Deputy Loss had served her the hearing paperwork.
I see. So this is as of March 23rd, correct?
Correct.
Okay. Anything else you want to bring up?
I believe it is discriminating against my disability that she uses her personal Facebook to make an appearance of myself that is not valid. It is falsified information. She has used the police against me in saying that I make false reports, which I have only made reports against her. The fact that she is talking about my children literally every day. And she claims that she is making monetization, more money on the drama here. And this is my personal life. This is my disability. She has no right to say, I am not disabled enough for her own, and then post it on Facebook, having people weaponize themselves and claim to say they can come to my town of Seaboing and open a can of whoop ass against me. I have done nothing against this person except for tell her to shut her mouth, stop screaming, stop cursing, come up and talk to the parents. There was no Spanish. I don't speak Spanish. She is making false claims against me. She even has people of Seaboing that have businesses comment about my mental health and how I am a psycho bitch. And that is unacceptable.
Do you have any other witnesses you intend to call?
Not present, but I do have an exhibit if
And what is your proposed exhibit?
it is her final message to the world about how she can continue to post whatever she wants on Facebook because it's her Facebook. And it doesn't matter who she posts about because she's allowed to do what she wants, even if it is harassment, even if it is saying she can stalk me and know my ins and outs, and that she deserves a peaceful environment. Yet, so do I. I deserve to have a space knowing that I lived there for 4 years. She still moved in. She claims that I have been intimidating her. And then she claims against that, saying that she's been ignoring me. I honestly forgot she lived there until these issues arise, sir.
Okay, hold on to that.
Mhm.
I'd like to hear from the respondent. Miss, how do you respond to all?
I'm here today because Brittany is my neighbor and we used to have a friendship. Our friendship ended in June of last year. I have made no physical contact with her besides a brief verbal altercation in the hallway about her kids being loud. I've lived in this apartment complex for over 6 months. I've never interacted with her. I went on with my life since June of last year. I've gotten pictures put on my door of me coming into my apartment with her own contents. I made police reports. I
Who did you make
also,
police reports with?
the village police
Village of
department,
Seaboing? Okay.
yes. And I've only made one police report in the last 6 months that, since our friendship has ended. There's only one police report and that's since I've lived, and that's when it started in March. I believe it might have been end of February, beginning of March. We stopped being friends because Brittany was complaining about other neighbors. I have a lot of personal messages between me and her about those neighbors. And I also have messages of pictures of those neighbors that she took in public places. I also have messages about saying she's going to kick the neighbor's teeth in. I also have messages from Brittany, how she's upset because She didn't like the way that the village police was handling her complaints, which I also have a copy of. 9 additional incidents for the Sebring Police Department have responded to complaints from Mrs. Wrightwood, which didn't result in a report being filed. They were documented in their daily logs. There's only 1 police report made against me. If I've been harassing her, as she states in her petition, for over a year, also with threats of saying that my boyfriend flashed a firearm concerns, said I have a pattern of habitual harassment. I called the police because I didn't know what to do about it. We had a brief verbal altercation in the hallway about her kids being loud. And since then, she has fixated and pivoted her harassment towards me because I showed the chief of police all of her personal messages. Even the ones regarding to he's not doing his police duty, he must not be doing his booty duty. And sent me a picture of their personal vehicle at someone's house in the community. I didn't know whose house it was. I sent all that information over to the chief of police himself so he could review it. In his defense, he confronted her and questioned her about it. That's his right to do. Why did you take these pictures? He questioned her. I think there might have been a post that he made on his personal page about it because it's really concerning behavior. No names, who took the picture, who sent him the picture. And since then, Brittany has filed so many complaints to the housing department, and these didn't start until 3/15, which was the day of the incident. She's been retaliating harassment against me because I'm sure she's probably embarrassed about her behavior. Integrity means a lot to me. I've been in this community for 5 years. I lived down the street from Brittany. Even after we weren't friends, we went our separate ways. I didn't want to be friends with her anymore. She didn't want to be friends with me because the chief of police, I have those messages, was on my personal Facebook page and she unfriended me. And I quote, "This is the last time I've ever contacted her on social media, and this is June 9th, 2025. If you didn't want me to talk to him anymore, that's kind of an odd request. It's not okay for what he did," meaning I'm acknowledging her feelings because I'm an empathic, I have empathy for other people. "Life goes on, and I won't sit and be mad every day about it. Push me out, that's fine. I don't trust people anymore either. Instead of coming to tell me you're upset, you unfriend me. That's not fair. That's your choice. Sorry I bothered you. You were my only friend here." She said, "Exactly. Life goes on." I said, "Please leave me alone. I didn't do anything wrong." And she puts, "Laugh out loud. You're something else." She then texted my boyfriend and said, "Grow the F up. You got to throw your 2 cents in another platform." I responded, which I shouldn't have. This was June of last year, by the way, Your Honor. I said, "Now you're texting Alex's phone. Don't harass me and get obsessed over a situation that you created in your head. I didn't do anything wrong but tag a cop in a funny post, and you've all been out of shape." It was a funny TikTok trend that I tagged Chief's personal Facebook in, and she was offended by it. She made me her enemy.
Okay, I just want to interrupt here for a second. The petitioner is alleging that you're posting all this on Facebook about disability and all this stuff. How do you respond to that?
No, I have personal messages between me and Brittany that was included into housing complaints that she was filing disability discrimination, and that was my defense.
So you're denying posting anything on Facebook?
There is 4 inches thick. I went through some of it. It's very emotional, distressing to see her own responses to things that are not even regards to her. I have a lot of neighbors. Some of my posts, they might have been about her, but it's nothing threatening. I have had Facebook for 16 years, the same account. I blocked her. I've changed my name, my profile picture, my cover photo, my location, and she's documented all of that. I don't know how she's seeing my page. I tried to block her from it. But then she puts it on my door, even after she filed the PPO. She continued to put stuff on my door as new evidence. She's taken pictures of me exiting and leaving my apartment complex and put it on my door, insinuating I called her a psychopath and a pussy. Excuse my language, I don't even like talking like that. But ever since I alerted the chief of police about her behavior, her harassment escalated.
Okay.
And I've lived here for 6 months.
I think I've heard enough.
I'm sorry.
No disrespect. Court sua sponte calls Chief Repke. Chief, would you please step up to the witness stand? Always welcome. Please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Sir, please be seated. Thank you. Please state your name for the record.
Stephen Repke, last name spelled R-E-P as in Paul, K-I-E.
Your employment, sir?
I am the chief of police in the village of Seaboyne.
How many years so employed?
As the chief here for
How many years in law enforcement?
40,
In your duty as the chief of police of Seaboyne, are you, as a part of your overall duties, to address complaints that may be filed by residents or anyone within the village of Seaboyne?
that is correct, sir.
And have you had the opportunity to hear what has been stated so far in the courtroom regarding what appears to be a dispute between neighbors within an apartment complex?
I have.
Okay, how many times have you gone out to either residence since June of 2025 pertaining to issues between neighbors?
Necessarily not gone out to, responded to telephone calls in context with the police department. I would say countless.
Countless?
Countless. I would 15 to 20 of calls I've taken in regards to complaints about the rules being violated in that apartment complex.
Right. When you had received these calls,
And it's not just me, Your Honor, it's my officers too,
sure. So at least 15 to 20.
that I could just off the top of my head.
Okay. But you're stating there could be more.
Yes, sir, that the other officers may have taken a phone call and didn't find that it's grown tiresome.
All right. And is it fair to say that when law enforcement receives a telephone call, whether it be through, well, typically through dispatch, you have a duty to follow through with it, right?
Correct.
And are there occasions where phone calls may come in that may not go through dispatch, for instance,
Correct.
that you would, or your department may address on the phone, and that would be the end of it?
As advice only, yes, sir.
Sure. And is that part of what has been happening here?
Yes, sir.
What are the complaints regarding?
Overall, noise in the hallway, noise from other apartments, kids riding their bikes in the parking lot, getting too close to vehicles, parking complaints about people parking in their parking spots, things like that.
And does this particular apartment complex have a manager?
Currently, I'm not sure. Then they did have a part-time manager.
All right. And typically, are those matters addressed through the apartment complex?
That has been our advice, that it would have to be addressed through the apartment complex.
So anything that you've received complaint-wise from June 2025 to present that would be alleged criminal activity by either of these parties?
None.
So being the eyes and ears of the village of Seaboyne, bottom line, what's going on here?
It occurred before June too. There was other neighbors that would make complaints.
Against who?
Miss Woodwright. There's others that have moved. It's been kind of a constant thing. And then it seems to have ramped up since June. And then it really ramped up once Miss Bazan made me aware that pictures were being taken of my wife's personal vehicle and forwarded to other people in town.
Is that concerning?
That was very concerning, Your Honor, so concerning that I made my officers aware of the incident, and I also made friends and family aware of the incident. My son reacted. It was my son's house that the pictures were actually taken at, where we often take care of our 2-year-old grandbaby that has a very rare disease. One that they really can't even put their fingers on, and my wife's often over there. So it touched a nerve, especially when my wife, who is a labor and delivery nurse and has dedicated her life to helping others, is accused of being on a booty call. I was highly offended.
Now, regardless of, and yet I'm not trying to put that.
No, sir, I understand.
Down, but does that have anything to do with how the department investigates any phone calls coming into your office regarding disputes between neighbors?
Absolutely not. It seems to have ramped up since then to the point that we actually received a complaint via Child Protective Services making allegations against Miss Bazan and her boyfriend that about a handgun being waved and things like that, which was never reported to the police department, but it was felt that it should be reported to CPS. I just feel that this has become a retaliatory thing against Miss Bazan.
Ms. Woodwright, do you have any questions of the chief?
I just know, Your Honor,
Well, no,
that
I just questions. Do you have any questions?
Ms. Bazan had contacted Chief after she had threatened me and I had made a report. And I know.
Wait, is
for a
that
fact-
your question?
Yes, I would like to
Okay,
know,
please phrase it in the form of a question.
did Ms. Bazan make a report and then, or after I made a report, contact you in regards to something that was about 6 months ago? And then that's what caused the concern and stir up between you and I.
Miss Bazan did. I had an officer follow up on a report that Miss Woodwright had made. Miss Bazan had come in on a weekend when I wasn't working, and the officer was able to follow up on the allegations. And then Miss Bazan did contact me after that. I'm very transparent in my community. If people want to friend me on Facebook, I very seldom turn it down. I've actually known Miss Bazan and her fiance since they were teenagers, from my time in Carroll, Your Honor.
Next question.
Would that include a personal relationship that would insinuate more of a belief system that the accuracy of what was told and shown to you against me, sir?
Would you please say that again?
The imaging and communication that allegedly happened between myself and Ms. Bazan, would your personal relationship between you and Mrs. Bazan have a greater concern for more of a belief that this is accurate and true communication that she and I had?
Not necessarily. I was concerned about the fact that my family was brought into the matter and that pictures were being taken of my family members within the community. I felt that it was a potentially dangerous and troubling situation. So did I weigh relationship any deeper or heavier with the Bazans and the Davises? I would say no. I try to weigh out everything as equal as possible and approach everything as impartially as I can. However, was I very concerned? Absolutely. Your actions by taking the pictures of my family within the community, I found extremely troubling. I take it as a threat to my family.
Any other questions?
And was there clarification made between yourself and myself of what had happened over social media after?
I accepted your apology. But that doesn't mean that I still do not find your actions extremely troubling. And it has caused apprehension within my family. My wife, my son, my children, my daughter-in-law, because I have to put them on notice that they're being watched in the community.
Any other questions?
If this was such a troubling situation and taken so seriously by Mrs. Bazan, why didn't she communicate that towards you sooner than until after a police report was made against her for harassment?
That's speculation. That's going into the mind of another party, which this witness does not have the ability to do. That motion, I'm starting with that question. Do you have another question? I have to follow the rules of evidence.
Nope, I just know, Your Honor, that this happened over 6 months ago. And if there was no date of when this occurrence had
You can
happened,
bring your argument. Do you have any questions, though? Any further questions?
was there a timestamp of when this had occurred?
I did not see one.
So it was a valid threat of right now presence.
I deemed it as such.
No further questions.
Do you have any questions?
Me?
Yes, so the chief.
I would just like to know why there was false allegations made of flashing of a firearm.
That's beyond the scope of this witness as well.
Other than
That's
that,
assumed as facts, not in evidence.
Other than that, I don't have any questions.
You may stay. Thank you, sir. You're welcome. Final argument.
My argument, sir. She is being honest with you. She is portraying the victim of something that has been an ongoing situation, which there are TikTok messages after I just unfriended her, Your Honor. And she then went to my partner at the time, messaged him, went to my TikTok, messaged me, blocked me, unblocked me, messaged me. I texted her phone that she gave me her number to, told her to just stop. Words lesser than what was said, stop. She then unblocked me and had more to say, which is in the documentation.
Thank you. Miss, your final argument.
My final argument is I have not committed any crimes. I do admit to having a verbal altercation about her kids being loud in the hallway, but other than that, that's between management. We don't have an on-site manager at the time. We have a part-time one, and they're well aware of these incidents as well as the false allegations. But other than that, I feel very unsafe in my apartment, even though I've been there for 6 months. She's shown a severe pattern of harassing others, not just me, and this has been retaliation. The PPO was filed after I told Chief about her behavior. And the reason why I didn't bring it to Chief's attention in June, the end of our friendship, because it was the end of a friendship. It's drama. Integrity and means a lot to me, and I brought my children to the community of saving to raise them there, not to raise them around chaos and disability discrimination and firearm concerns, accusing me of using drugs. It just goes on and on. We could be here all day if I sat here and read everything that she has said against me, but there's no police reports. Just one about me yelling at her in the hallway of our apartment complex. All these other police reports with everybody else, all the other tenants, prior and current.
Thank you. At the conclusion of a hearing requesting a personal protection order, the court has to state the reasons for either granting or denying the personal protection order request. That's pursuant to MCR 3.705 as well as MCL 600.2950(7). Also, if the petitioner is requesting a non-domestic stalking personal protection order, the court has again state the reasons why either granting or denying. And that's what the court is doing here. The initial petition was requested ex parte. The court denied that based upon the information that was contained within the petition being insufficient. In this case, we have a relationship, a friendship apparently that broke off either in May or June of 2025. And essentially the relationship went off the rails. According to the petitioner, it was constant harassment, posting of messages, etc. on Facebook. contact in the hallway, etc. All these activities allegedly going on. Further, the petitioner is claiming that messages have been posted since then, which she believes to be, again, reason for a non-domestic stalking personal protection order. The respondent, on the other hand, states in part that the petition, strike that, not the petition, but the friendship broke off again in May or June of 2025. And since then, there have been ongoing issues in the apartment complex, potentially loud noises, children playing in the hallway, whatever the situation may be. But she states under oath as well, as a petitioner with completely opposite evidence, testimony, that she's not posting anything. I inquired of the petitioner regarding whether names were specifically posted of individuals, of the petitioner, stated by respondent that something was going on here. And there are none. But you also have to think about, well, is there something else going on here that's a problem? And there are even allegations now of, for instance, someone carrying a firearm, displaying a firearm, which at a minimum, the court can take judicial notice, at a minimum would be at least felonious assault, potentially a 4-year felony, unlawful display of a firearm. I mean, these are serious allegations. These are criminal allegations. Police were not contacted. However, Department of Health and Human Services apparently was contacted. And there's nothing in the record to indicate to the court whether or not anything was followed up with that investigation or not. The court, on its own initiative, sua sponte, had called Chief Repke, Stephen Repke of the Sebring Police Department. I saw him in the courtroom. Actually, when the case was called, I saw him stand up, and which drew my attention to him as well. And so I'm trying to find out what indeed is going on here. That's what all the court's trying to do. And the reason for the court doing that is, at least from my experience, when it comes to law enforcement, the purpose of a police agency is to protect and to serve, number one. Number two, they're to investigate criminal complaints, request arrest warrants, file charges, etc. That's their job. And Chief Repke had taken the witness stand. And I had asked him regarding what may be going on. And what it sounds like is just constant calls, countless, I think was his word specifically, countless calls coming into the Sebring Police Department, not only himself, but his other officers, regarding disputes or issues going on inside this apartment complex. Even issues where someone's parking in the wrong parking spot, or you know, trivial matters like that. It may not be trivial to those who are at the apartment, but it's trivial, generally speaking, because we're talking about non-domestic stalking. We're talking repeated contact where there are threats involved. And what the court heard was basically what I find, based upon the testimony, simply a relationship that's gone bad and toxic to the point where, as soon as this court finds that if the respondent is even around the petitioner, and I can't help the fact they live in the same apartment complex, it brings up all these bad feelings and all these allegations are made. And I mean, it's just thick as thick can be here regarding what's going on, or what's alleged to be going on here. To add fuel to the fire, I get a response from the respondent who's testified under oath that the petitioner, though she may be afraid that she's being stalked, posting messages on the respondent's apartment door. That's what she testified under oath. I allow final argument to allow the parties to raise their points, and then the court can make a decision based upon having all the knowledge here. Not once did I hear in the petitioner's prayer for relief and or final argument to say that's not true, that didn't happen. So it's uncontroverted that petitioner is putting things on the respondent's door. And I know for the record, the petitioner shaking her head, but there's nothing in the record indicating that that was not done. So it begs the question, why in the world would someone need a personal protection order based upon alleged stalking when, one, the individual is not referenced in any Facebook messages, second, the respondent denies them that there were posts, but more importantly, the petitioner continues to go to the respondent and put items on the door. Why in the world would you do that if you were afraid or you were stalked? There is absolutely no evidence in this case for personal protection. Personal protection order request is respectfully denied. That is all. Off the record.
It's TCF Live on a Super Friday. Women behaving badly with Judge Prill, ladies and gentlemen. Lindsay, thank you for the $2 super chat earlier. And Michael, thank you for your $2 super chat. Appreciate you both. Let's go back to Judge Elmore. Let's go there.
I'm Jeff Harrison. I'm here on behalf of Ashley Crozzi. She's now joining me at the table.
Thank you. You may be seated. Crozzi is currently in pre-trial custody. We're here today for a couple things. Looks like we have got a pre-trial hearing maybe and a bench warrant. So I'm going to go over a few things. This court issued a bench warrant on March 19th. Should have been last Thursday, initially for testing positive for the controlled substance methamphetamine and the controlled substance of marijuana presented through the metabolite of THC. And then subsequently, they're also related to that. On that same day, allegedly the defendant failed to appear for testing on or about Saturday, March 14th. And what are we doing today, Mr. Harrison?
She's prepared to make admissions as to the material allegations. The only thing that might cause us some trouble is the failure to test allegation, for which she did not have any prior knowledge.
All right. Ms. Crozzi, am I saying it correctly?
Yes, sir.
Thank you. Please raise your right hand to the best you can. Do you swear or affirm the information testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. All right, so Ms. Crozzi, you were out on bond in this file, and you were ordered not to possess or use or consume controlled substances and to be randomly tested at community corrections. And it appears that you went down, signed up for testing. Is that right?
Yes.
Now, I'm told you're going to admit to violating this condition. I need to let you know that you do have the right to due process, which means you could have a contested hearing and the prosecutor would have the burden of proof to try to demonstrate that you violated your bond by violating the orders of the court. Now, failing to comply with an order of the court could be considered contempt, but the court doesn't use that power. Contempt could get you up to 90 days in jail, up to $7,500 in fines and costs, but the court doesn't go down that road. The court only looks at this as a review of your pretrial release conditions pursuant to Mission 406.106. Now, also joining us this morning is Ms. Stark from the Community Corrections. I'm told today that you were admitted to testing positive for methamphetamine and marijuana for violating that order and consuming that substance. If you do, you'll not have a hearing of any kind. Does that make sense?
Yes, Your Honor.
All right. And has anyone made any promises, threats, inducements, or to compel you to admit to violating your bond in this way?
No, Your Honor.
And therefore, Ms. Crozzi, is it true that on March 19th of this year, you reported to community corrections, provided a sample for testing right?
Yes, Your Honor.
And was that a urine sample?
Yes, Your Honor.
And did it tested positive for consumption of methamphetamine and marijuana? Is that correct?
Yes, Your Honor.
And when was it that you used that substance? Those
For
substances?
marijuana, it's been in my system this whole time. I was a daily user prior to all this, so she told me that would be in my system for a while. But the
Wait.
last time I used marijuana was the end of February, and the last time that I consumed meth, was a day or so prior to me testing.
Okay. All right. Ms. Stark, do you know when she reported to community corrections initially? Like, when did she start the testing? Is what I'm looking.
Her first test was on March 10th and she was positive.
Okay. And when did she, was that was her first test, you said?
Yes.
All right. Mr. Carnes, are you satisfied with your proofs?
I am, Your Honor. I'll just dismiss any marijuana allegations because I know that can stay.
Okay.
But
It's okay.
Okay.
I was gonna make sure, it can stay in your fat cells. But I don't want to say fat related to a woman in public, but great, now you made me do it.
Yeah, I'm sorry.
All right.
It was a big fact.
No offense, Your Honor. None taken.
Thank you. Mr. Harrison, are you satisfied?
I am indeed.
All right. The court is as well, and I find that the admission today is made freely, knowingly, and voluntarily. The court finds that the information provided in the file, as well as stated by Ms. Crozzi, is that she violated the terms and conditions. Therefore, the court finds her in violation of her bond for the consumption of methamphetamine. All right, so now becomes the question about what to do with the defendant. I note here on the felony information, she's got a charge of possession of meth, assault with a dangerous weapon, a machete, and assault resist obstructive police officer. I note that the possession doesn't have any second or subsequence. And I also note that there's also a charge of fourth or child abuse in the 4th degree.
That
But here's my point. I don't see it at a prior felonies.
Right.
Go ahead, Mr. Carnes.
That's correct, Your Honor. I think there should be a second subsequent controlled substance. She does have no, never mind. She's not eligible for 7411, but we still can't use that.
It was
She had
dismissed.
Successful 7411.
And when was that?
It was marijuana, so it was some time.
All right. Ms. Stark, again, she had just began testing a couple weeks ago, correct?
First test was on March 10th. On March 14th, she was a no-show. And then she appeared on the 19th.
All right. Okay, Mr. Carnes, what do you want? What was your recommendation?
Your Honor, at this time, I would ask the court to remand the defendant. The reason that she is on bond for possession of methamphetamine and using methamphetamine while she's on bond. I'm covering for Ms. Carrie, so I'm not going to say too much, but I'm sure Mr. Harrison wants to make a motion with treatment plans in the future. That would be something my office would consider, but at this time, I do think a remand is appropriate.
Mr. Harrison, before I turn to your recommendation about bond, I see that we're also here today for a pretrial. And
Is that scheduled concurrently, Your Honor?
it is.
Okay.
So I don't know. So I'll ask you to fill out the court's forms for that, but do you know whether or not there is a resolution to the case today?
There is not, as it stands right now. We are working toward that.
That's fine. That's all I need to know. All right, so now
I will fill out the sheet for you. I'm sorry.
it's all right. You're fine. So that means I jump ahead to the question about your position and what to do with bond.
Regarding bond, this case is unique to the extent that she posted a $25,000 surety bond with the court on the 4th of March, I believe, Your Honor. And that has not been obviously forfeited or called in by the bondsman or anything like that. So that would remain available to her, does remain available to her in terms of securing her pretrial release. As Mr. Carnes sort of indicated, we are working on arrangements to find a rehab placement for her. We actually have one. We just can't get the dates to line up, and we're working with Harbor Hall to get us in front of it so we can file a motion and do the proper procedure with the court. I don't know why I stumbled over proper procedure. Maybe it was the alliteration. The long shot of it is she's got a $25,000 bond hanging over her head, a bondsman. And we're working on getting her into rehab. She has a concurrent case involving the same child that's a part of the incident in the current matter that she needs to attend to as well. Obviously, she could do that much better if she's not in jail. She would be staying with her grandparents. Yeah, she has a job. So
Where do you work?
I am a manager over at the 115 McDonald's. I was offered my job back when I was currently out on bond.
Okay.
I've been a manager over there for the past 4 years now.
All right, Mr. Harrison, I already know what I'm gonna do.
okay, I'll stop talking.
That's all right, probably a good idea. So a couple options, Mr. Trudy, and I know what I'm doing and I'm doing it for a reason. I'm going to set the hook and see if you mess up. If you do, then you just give me a reason to lock you up longer if there's a plea or a conviction. Okay. So when the legislature changed the statutes a few years ago and said that for intermediate sanctioned cells, we're supposed to start with the presumption of no jail and just probation and costs for any felony. It tells judges, if you're gonna give jail, let them see if they mess up. You've already messed up once. So I'm going to release you back out on your bond, and I will add to it that you are to enroll in an enhanced outpatient treatment program through community corrections. That's going to be a treatment program. Now, also, who posted the $25,000? Okay. Next time you go to use, going to be 25. It's a really expensive hit.
Thank you.
$25,000 is what that hit's going to cost you potentially. I'll put your bond and put you in jail. So if you do, and I'm not trying to say, oh, that guy's trying to be a real mean guy. No, I'm trying to give you incentive that before you inject it or smoke it, you go, oh, does that look like it's worth $25,000?
I lost my children. No.
So I'm setting the hook. Let's see if you do well. Thank you very much. Anything else, Mr. Carnes?
No, Your Honor.
Mr. Harrison?
Nothing further, Your Honor. Thank you
Just
very
started,
much.
we did hear from you. Do you have anything else? No? By the way, she's almost wearing orange too. Disregard.
Thank
We're
you, Your
adjourned.
Honor.
Thanks.
Appreciate it.
Yep.
Have a great day.
Thank you, you too.
TCF Live, it's a Super Friday. Speaking of which, thank you, Grandma TCF, for your $2. We're halfway to our goal today. So I gotta tell you, it is Women Behaving Badly Day in Huron County. I give you the case of Hope versus Maddie now. Hope versus Maddie.
PH, it's really Madeline Toner, but the petition reads Maddie Toner, so that's why the court stated as such. Case number 26-8175 PH, the time and date set to challenge a personal protection order that was granted by this court on March 16, 2026. Both parties are present. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Back on March 16, 2026, the court received a personal protection order request. And that was requested ex parte, which means that it was requested without a hearing. And after the court reviewed the petition and reviewed the attachments, including a police report, the court issued a personal protection order against Ms. Toner. And in its reasoning, the court stated there were two separate acts of contact with the petitioner, including sending an intimidating social media message and alleged assault and battery and/or assault upon the petitioner. Ms. Toner is challenging that, and that's what this hearing is about. The burden of proof rests with the petitioner to continue the personal protection order. So I am going to ask Ms. Bedford to explain why you believe this personal protection order should be continued. Go ahead, please.
I have written a statement and I do have a copy to turn in as an exhibit as well. Do you
Why don't you just read it into the record, please?
Okay.
That's your statement.
My name is Hope Bedford. Before the assault, I felt safe living in my usual routine. After it, my life has been constricted. I do not feel safe going out in public anymore, anticipating that I will run into either Heather or Madeline. This incident has changed aspects of my social life by making me question where I can be at with my friends without being attacked by these individuals. The physical injuries healed, but for nearly 2 weeks, sleep has no longer been restful as I could not turn off my thoughts. I have been anxious while at work and then have had to explain why I wasn't attending activities that I was attending before the assault. The pain wasn't only scratches and a busted lip, it has also been the daunting feeling of being stuck in fight or flight mode. I do not feel that it is necessary or required to be put in a situation again where I have to defend myself. This pertains to any physical and or verbal assaults in person or online that may be directed at me. Emotionally, I have been living with fear and anger simultaneously. I feel angry that someone else's actions forced revisions on my life that I had never asked for, modifications on where I go, what I do, and who my trust have taken place in my life. I am only 26 years old, and I believe that I should not have to walk through my daily routine wondering what will happen to me next. I shouldn't have to walk around in fear. The fear and emotional distress I experienced are ongoing and directly tied to the incidents that led to the original order. I am most concerned about the retaliation that may take place due to me contacting local law enforcement. The night of the assault, I was completely humiliated in a room full of friends and patrons who frequently visit my place of employment. Madeline decided it was acceptable to put her hands on me and verbally assault me while doing so. I believe a termination to this order does not fully reflect the seriousness of the verbal and physical assault that I had experienced. I was the one who received the threatening message from Madeline. I was the one who was verbally assaulted and then physically assaulted on the night of the 14th. Therefore, I am attempting to protect myself and ensure that I won't be in any additional situations or with reoccurring scenarios. Since the incident, I continue to feel vulnerable. Madeline's past actions have demonstrated a disregard for my safety and personal boundaries. I respectfully ask the court to consider the sustained impact on my security, my work, and my mental well-being, and to establish provisions that protect me moving forward. My intention is not to escalate the situation, but to ensure my safety and prevent further harm.
All right. Ms. Bedford, your last name is spelled Bedford?
Yes, Your Honor.
All right. Ms. Bedford, prior to, I obviously read the petition and I've read the response. Prior to February 13, 2026, was there a relationship, friendship, acquaintance between you and the respondent?
No, not at all.
Okay. And as I read in the petition, apparently on the 13th of February, you were at a local establishment. We don't need to name it, but you were at a local establishment. And what was your purpose in going to that establishment on February 13th?
My coworkers and I would often go to the wash after our shifts, as it is right down the road from our establishment, just to sit and mingle.
All right. And on that day, were there things said by you that caused some sort of stir in the room? Or explain what happened? What happened on that night?
Me and my coworker were having a personal conversation in regards to people who he had went to school with and people that I had known. And I had mentioned Madeline Toner's name, and we began discussing her.
Okay,
And
let me stop you. You said a personal conversation. What does that mean?
as in, like, we weren't talking at a volume to where I would be concerned about what I was saying.
Okay, so are you stating that you're not, you know, for instance, let's say you were talking about me. Well, Prill is this, Prill's that, you know what I'm saying? The loudness and for all to hear. Are you stating that that's not what occurred?
Correct.
Okay, so you're having some sort of conversation regarding Ms. Toner. How did you know Ms. Toner if you really didn't have an association with her?
I used to be friends with somebody who was friends with her.
Okay.
Yes.
Okay,
So I
so-
never,
And I don't want to go into what may have been said by you, but something was said regarding Ms. Toner, correct?
yes.
By you.
Yes.
What happened next?
Her mother had approached me and told me, I just want to let you know that is my daughter. I don't appreciate you speaking about her. And immediately I apologized.
Okay. How do you know that this is Ms. Toner's mother?
I had no idea until she had told me.
Okay. And was her mother also a patron that night, or?
She was the bartender.
Oh, okay, she's a
Yes.
bartender.
Yes.
How far away were you from her when you were having this conversation with your friend?
I believe that as I was having this conversation with my coworker, she was walking up to the table.
Okay,
Yes.
so fair to say she overheard something.
Yes.
Okay, so you get confronted about it. Was it respectful?
No.
Why, explain to me why you feel it wasn't.
She was very nasty towards me after, and I admitted, I said, I am wrong and I apologize. And it just kept going and her volume just kept getting louder and louder.
Okay. After that happened, what happened next?
I had received a message from Madeline via Facebook Messenger. And I do
Is
have.
that the one that you
Yes.
submitted? Okay,
Yes.
it's court reviewed. Did Ms. Toner's presumed mother do anything to you at the bar? Because there's something about banning. Do you recall that? Did something happen at the bar that night?
I went to leave and I was going to go and apologize to Miss Toner's mother again. And as soon as I put my coat on, she looked at me and said something along the lines of,
Well, we can't go to what was said, but bottom line, were you banned from coming back into the?
I was not, no,
No. Were there any words to that effect? Just get out?
just get out.
Okay. Did you comply with that?
Yes.
Okay. After you left the establishment, when is it that you claim this message was sent from Ms. Toner to you?
This message was sent while I was still sitting in the establishment.
Oh, okay. And just want to read it into the record so we have it clear. According to this, must not have anything better to do with your effing time, huh? Have to go and run your mouth at the local bars, question mark. Small town, word travels fast. Better watch what you have to, I'll say, effing say. Is that the message?
Yes.
How did you take that message?
As a threat.
Why?
Because the last sentence, you better watch what you have to say, that I took that as a threat because I did apologize when I was wrong.
Okay. So after the message was sent, anything go on after that?
I left the establishment.
Right, but any other communications or interactions between you and the respondent up until March 14th.
No, not between me and Miss Toner.
Okay, radio silence, right? No issues.
Yes,
Did you go into this establishment prior to March 14th?
no,
Why not?
I just avoided it.
Okay. However, you claim that you went into the establishment on March 14th, correct?
Yes, Your Honor.
And so we're talking a little over 2 weeks ago, correct?
Yes, Your Honor.
Okay, I'm just looking at the calendar. You go into the establishment for what purpose?
To celebrate a friend's birthday.
Okay, so you go in, correct?
Yes.
What happens?
I immediately after I walked through the door, the respondent's mother, Heather, was standing on her chair screaming my name. I did make eye contact with her, but I decided that I was just going to ignore her. And I walked over to a group of people, friends / coworkers that were in the establishment.
Was this person working that night?
The person we were going to celebrate.
No, I'm sorry, what you believe to be, who you believe to be Ms. Toner's mother. Was she working that night?
I don't believe so, no.
Okay. And was Ms. Toner in the establishment as well?
Yes, Your Honor.
Okay. Now, what happened after you claim mother was either yelling your name or made some sort of fracas here to get your attention? What do you claim Ms. Toner did?
After the statement was made, shortly after, I was approached by not only Heather, the respondent's mother, but the respondent as well.
Okay. And what happened?
Basically, Heather decided that she was going to verbally attack me, and then she verbally assaulted me. And then shortly after, Madeline did the same as well.
What do you mean by verbal assault?
Just saying, like discriminatory things, calling me, cursing at me, stuff like that.
Okay. You allege in your petition, though, that there's something physical that happened as well.
Correct.
Now, I want to focus, let's focus first on respondents you claim mother.
Yes.
All I want to focus on is what happened in the establishment at the time. What do you allege that this individual did?
She shoved me.
Okay. Did you approach her?
No, I was approached by her.
Did you incite her in any way?
Absolutely not, no.
Okay. As a result of the push, is that when essentially all, for lack of a better phrase, all hell broke loose inside the establishment?
Yes.
Okay. What did you see, if anything, of what Ms. Toner may have done?
To me personally?
Yes.
She was standing in front of me. She was looking me dead in my eyes. She had pushed me. I went to defend myself. She had stated, I am pregnant, you cannot hit me. So therefore, I took my attention off of her and back to her mother.
Okay. Did you confront her, Ms. Toner?
No, Your Honor.
Who approached who?
Madeline approached me.
Okay. And as a result of this alleged melee, were police called?
Yes, Your Honor.
Okay. Police responded?
Yes, Your Honor.
And some sort of complaint was made?
Yes, Your Honor.
Okay. Why do you believe a personal protection order, in your own words, and I know you read your statement, I appreciate that, but why do you feel that we need to continue this personal protection order?
I feel like you need to continue, the court needs to continue this personal protection order for my safety. I feel as if the personal protection order was lifted off, that there would be more incidents to be taking place. I feel like there would be more verbal incidents and even possibly physical incidents as well.
You placed in your petition that you were allegedly barred from going into the establishment. Do you recall that in your petition?
Yes, I want to say that personally, no one has reached out to me to let me know that I was barred.
Well, you've alleged in your petition that apparently you reached out to the establishment owner. Is that correct?
I don't believe so, Your Honor.
Did I read that wrong?
I believe that my manager, my dining room manager from my workplace had reached out to.
Oh, okay, yes. Okay, that's right. In your petition, you allege that your EB
Mhm.
made contact. And were you indeed barred from the establishment?
Not to my knowledge, Your Honor.
Okay. All right. Anything else you want to add before I ask whether you have any other witnesses?
No, Your Honor.
Do you have any other witnesses?
No, Your Honor.
All right. Ms. Toner, this is your opportunity. How do you wish to respond?
So I received I was served with the PPO. I then went and filed a paper to terminate it.
That's why we're here.
If you read the witnesses that have wrote statements on our behalf, my name is not included. This is an issue that happened with my mother, who is the bartender, and I don't feel like I need to be involved. Yes, I did send a message. No, it was not threatening in any way. I have never spoke to her. We were friends on social media. After I sent my message, I didn't find it necessary to have her on there because she was spreading my personal information around in the public that I didn't feel was appropriate. So I unfriended her. Unfortunately, I was put in the middle of a fight or whatever you want to call it. The night on the 14th.
March 14th.
And I stepped in to intervene. When I stepped in to intervene, at this point, it had already escalated. And yes, I did make this statement. I am pregnant, but it wasn't something that, you know, nobody knew at that point because it was already being spread around the town. I just don't feel like I need to be in the middle of it. If you read the witness statements, I am not the aggressor. I am not the attacker. Everybody had made that very clear. And as a result of what happened the night on the 14th of March, I ended up in the hospital with major abdominal trauma, which I have provided medical records for that.
Well, you provided records of conditions of treatment, but there's nothing. I did review it. It gives you steps on what you need to do.
I have the paper.
Let me take a look here. Follow-up procedures, future appointments if necessary.
The triage patient summary.
What page is that?
It should be the first one attached after my statement. And it's down at the bottom, it says discharge diagnosis.
1:21 weeks gestation of pregnancy,
Yes.
2 trauma during pregnancy.
Yes.
Okay. All right, and I believe you allege in your response that someone had struck you, correct?
Yes.
Not a petitioner.
I was pushed, but I was pushed because
Well, no, but please answer my question. The petitioner didn't push you or strike you, correct?
during everything that was going on, yes, I was pushed.
I didn't ask whether you were pushed. I asked whether or not you were pushed by the
Yes.
petitioner. Where did you list that in your response?
In my statement. Page 4.
Okay, you state Hope had pushed me into the bar and in self-defense.
And in self-defense to protect myself and my unborn child, I retaliated back and pushed back.
Did you review the police report that was provided regarding this as well?
No, because this whole incident is not being investigated by the Buchanan County Sheriff's Department. It's being investigated by the Michigan State Police.
Okay, but that night it was investigated by the sheriff's office, correct?
Correct. When I had given my statement, Officer, can I provide names or?
Oh, absolutely.
Okay. Officer Strzeski came out to talk to us, and at the time, from my understanding, there were no charges or allegations being pressed against me. They were all against my mother.
An individual by the last name of Indu, I-N-D-O, does that ring a bell?
Yes.
Who is that?
She's a bartender at the establishment.
And what's her first name?
Nicole.
Nicole? How do you know Nicole?
She's one of the bartenders at the Wash, and then she is a cousin, I believe.
Okay. And I don't have it in front of me, but according to the police report that the court had the opportunity to review, and I don't know why it's not here, but it indicated that the pushing or the behaviors really were focused on your mother and in part on you. There was nothing that I recall of any pushing. So, and I could be wrong, but apparently the Michigan State Police is investigating this now.
Yes, it was all turned over to them.
Okay, all right. Have you heard anything regarding the status of this?
I haven't spoke to them in probably a week.
So are you stating that the petitioner went up to you and pushed you?
During the fight, yes.
Where were you originally when all this started?
So after my mom had called Hope and her boyfriend by their name when they had first walked in the door, I said, it's time that we leave. I had already paid our tabs. I said, it's time that we leave. You know, I can already see where this is going. I said, we need to go. We were waiting for my aunt. She was in the bathroom and my mom had walked up to the front, well, where the bar section is. And I followed her because she was already aggravated. And I said, no, it's time to leave. And I had gotten, after Hope and my mom had their altercation, I had stepped in the middle to try to de-escalate it. And
But you were expecting, why in the world would you do that?
there was a lot of drinking involved.
By who?
My mother, my aunt.
Well, why were you even there that night?
I was just getting dinner and I was their driver's back home.
At 10 in the evening?
Yes. They had been drinking and
They
asked
served
about-
dinner 10 o'clock at night?
They stopped serving at 8. Stopped serving dinner at 8 o'clock.
Okay. Does the last name of Koth ring a bell?
Yes.
The court recalls when it authorized the petition that you claimed that you were punched, or someone claimed, it may have been Zindu, that claimed that you were punched by someone by the last name of Koth.
Yes.
Is that correct?
Yes.
Okay. All right. Anything else you want to add to this?
No, I guess just after reviewing 2 different two different statements that I had been served with, and then as a copy of what was sent to me on 3/18. There's two very different stories. Like I said, in each statement from each witness, my name's not even listed. And I just don't feel like this is a situation that I need to be involved in when the problem did not originate with me to begin with.
Okay. Do you have any witnesses you intend to?
Not that I can present today, no.
Okay, all right. All right, Ms. Bedford? No other witnesses? This is your argument. Anything you want to say?
Yes, I do believe that these personal protection orders, do need to stay in place for my safety.
But it's now alleged that you pushed Ms. Stone.
That is incorrect.
Okay, but, and maybe I failed to ask this, but I'm going to ask this. How is it, you described how Ms. Toner's mother confronted you. I guess I need to know, what is your side regarding whether you had any confrontation with Ms. Toner that night, March 14th?
So I was first approached by her mother, and then she was to follow behind her.
Did you move at all from your location when you were initially?
No,
Okay.
no,
So if you're stating that if Ms. Toner had contact with you, Ms. Toner would have approached you, correct?
I was approached by her.
Okay, and I'm assuming you're denying that.
No, I did approach her.
Okay. Okay.
After the statement was made, she had made the statement to my mom, you're an effing B, get out of my face. You can't tell me that I can't be here. And then she looked me dead in my face and said, the same exact thing, and you're an effing B too, get out of my face.
Okay.
And then after that, that's when all hell broke loose.
Understanding. Your final argument then, please.
What I said previously, I guess I will use as my final argument.
Okay, fair enough. All right, same as in the last case, except this personal protection order was granted. The respondent may file a motion to terminate a personal protection order within 14 days of being served of it. She's timely done that. And the hearing is scheduled. The court has the opportunity to hear the evidence presented, and the petitioner has the burden of persuasion in a hearing held on a motion to terminate or modify a personal protection order. That's under the Pickering case, 253 Machete 694 in 2002. The court heard testimony of a situation that occurred on or about, I believe, February 13 initially, 2026. Petitioner enters a local establishment, and according to her testimony, was with a coworker or supervisor, but again, friend or coworker, and they were a particular spot in this establishment, and they had a private conversation. Part of the conversation apparently involved the respondent. Come to find out, the respondent's mother works at the establishment, had clearly overheard what was stated, and as a result, there was interaction between the petitioner and the respondent's mother. As a result of that, according to the petitioner, she claims she apologized for her behavior, for making her comments, and for whatever reason, it didn't stop there. She attempted a second time, according to her testimony. And at that point, not even before the petitioner left the establishment, a message is sent, appears via Snapchat, and I'm going to read the whole thing into the record. I don't like doing this with the cuss words, but it bears repeating at 11:37 p.m. Must not have anything better to do with your fucking time, huh? Have to go and run your mouth at the local bars. Small town, word travels fast. Better watch what you have to fucking say. I don't like saying that, but that's the message. According to the petitioner, she felt threatened by that message. Respondent says, no, that's not a threatening message. So the court has to consider that. Fast forward to March 14, 2026, and the court recalls in the initial petition that the respondent's mother had claimed to have barred the petitioner from going back into the establishment. However, the initial petition also indicated that petitioner's supervisor contacted the owner of the establishment who stated there was no such barring. That was in the initial petition. March 14 comes along, evening hours, 10 o'clock, 10:30, whatever the time may be. Respondent claims she's there for dinner. Petitioner comes in. Petitioner has someone with her. Petitioner's boyfriend, I believe. I don't know if there were any other individuals there. I believe there were. They went into the establishment, and the respondent's mother, who was not working at the time, raises her voice, starts calling out the petitioner. All while this is happening, respondent is in the establishment as well. It appears to the court, according to the testimony, petitioner stood up, or I should say she stayed in her spot. Respondent's mother went and approached her. We have alleged pushing, and we also have the respondent, according to the petitioner, approach the petitioner and push her. That's what she stated. Respondent's position is, I was minding my own business. It's really my mother. And when I saw things were going bad, it's time to leave. So respondent attempts to leave. She claims petitioner went to her, pushed her, and then the melee that happens. Now, clearly there was one unconsented communication between the parties on February 13, 2026. Now, mind you, talking about other people can cause problems, clearly. And it did in this situation. I don't know the details. I don't want to know the details of what may have been said, but apparently there was a private conversation between the petitioner and a friend or coworker. Things were said, allegedly privately, still heard by respondent's mother, and that starts it. Before the petitioner leaves, as stated, the message was sent at 11-something in the evening. And respondent's position is, that's not a threatening message. Court takes judicial notice of the last sentence. Better watch what you have to effing say. Okay, we'll leave it at that. Fast forward to March 14, 2026. Petitioner re-enters the establishment. And I already brought up what the allegations were between the parties going on. And what I find significant to determine, because it's a burden of persuasion that is upon the petitioner to maintain the personal protection order. The response of the respondent is, hey, look, I'm kind of caught in the middle. It really involves my mother. I shouldn't be a part of this. I just want to be out of it, which is understandable. But petitioner claims she never approached the respondent. Respondent claims she did approach, but she was trying to get out of the establishment. That's what she stated. Petitioner said when she was approached, that respondent was in her face and get out of my face. Respondent claims that the petitioner also said that get out of my face. That would indicate to the court that the respondent approached the petitioner. Why would she state that? And why would the respondent admit that the petitioner made that statement if the respondent did not get into the face of the petitioner? That is the second unconsented contact. Regarding pushing, petitioner claims she didn't push, respondent claims she did, petitioner pushed her. But the court takes judicial notice of the initial petition in the police report, which indicated that the reason for the alleged trauma of the respondent was some sort of punch that was from a third party, unrelated to the petitioner. Court finds 2 unconsented contacts. Personal protection order is appropriate and it shall continue. That is all. Off the record.
And at least for the moment, that brings an end to women behaving badly with Judge Prill. I'll keep an eye on his court, see if he has any more hearings today. But that was interesting. Let's go to Texas, and we'll see what's going on with Judge Stevens.
Pronounce your first name, Duracia or Duracia? Duracia Williams. And Mr. Kindler is here and the state's attorneys are here. As you know, there's a motion to revoke unadjudicated probation in this cause number 25 CR 425. Does the defendant waive a formal reading of this motion filed on December 12th of 2025? Can we proceed in summary?
Yes, Your Honor.
First thing we're going to do, there was an issue raised by the defense on the defendant's competency as to whether she was or was not competent to proceed with her proceedings. The court ordered Dr. Edward Pond, licensed psychiatrist, to evaluate the defendant. He is prepared, and we've received a report dated March 20th, 2026, finding the defendant to be competent. I'm going to call this report Court's Exhibit 1 on this date.
It's here to stay.
And it will be made a part of the record in this proceeding without objection.
Okay.
So I don't think.
Okay, it is received. And we can proceed in summary.
Yes, sir.
Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion to revoke unadjudicated probation filed in December of last year in this cause number 25 CR 425 states that on July 9th of last year, 2025, you were placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, a third-degree felony. Is that true?
Yes.
One states you committed the offense of assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of your probation order. Is that true or untrue? Did you, have y'all talked?
I think she's previously here.
No, this is the only motion here, and there's nothing on the face of this. I would write on it.
Judge, I wrote on mine that she entered pleas of not true on January 30th.
Okay.
And
I wouldn't put that. Well, I thought, what are we doing? Is she admitting to anything here? And what's
she didn't admit to anything back on January 30th. We conducted a hearing.
Okay, what are we going to do today? Is she going to admit?
She's been found competent. I think the issue of competency was raised prior to a disposition.
Well, there it is.
She's been declared competent, so I mean, we will proceed to a disposition at this stage.
Well, that's what we're trying to do. So what are we going to do?
Your Honor, my understanding is that the state presented all of its evidence on January 30th. I had Officer Lonick testify about the proof as to the assault that he occurred to him, as well as the fleeing. And that was where the state limited its evidence on presentation on January 30th.
That was January 30th, right?
January 30th, counts 1 and 2. We have video evidence that showed that the fleeing was, in this lawyer's opinion, obvious. And then there was the body cam footage that showed where she struggled and kicked him in the appropriate areas alleged in the assault.
Yeah.
And if necessary, we can retrieve the video that was placed in evidence to remind her of the evidence. So after I passed the witness and Mr. Kimler was cross-examining the defendant, he was raising the issues about her mental stability. And out of caution, Your Honor, ordered the examination. She's been determined to be competent. I would ask that the court.
Let's pick up where we left off in that hearing.
I would ask that the court make findings of true as to counts 1 and 2 and proceed to punishment.
What do you have to say?
Disposition. I think that's accurate, Your Honor. And then if my refreshes my recollection about what occurred, I think while the report, if I could slip over and learn that somewhat while the report does find it to be competent, there are some indications of mental health issues that may militate in favor of more lenient treatment with the disposition of the MTRP.
Okay, then the court will find that based upon the earlier hearing and this hearing and presentation of evidence concerning defendant's competency, where the defendant is declared competent, that the defendant pleaded true to, she didn't plead true, that the court found, based upon the evidence presented, true to allegations 1 and 2 by a preponderance of the evidence or greater, that the defendant committed the offensive assault of a public servant on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her probation order, and that she committed the offense of fleeing a police officer on or about October 19th, 2025 in Jefferson County, Texas, in violation of condition 1 of her deferred or unadjudicated order. The court not only deems it meets the threshold for preponderance of the evidence, but the court found it true beyond a reasonable doubt in each of these cases. So what shall we do? Defense.
Well, Your Honor, many times, thank you. I think when people are faced, which some people are faced with an interaction with law enforcement, they react in a way that doesn't seems to defy explanation. I would observe that Ms. Williams is on probation for a previous offense of dating, which of course involves the action of law enforcement. Now, that's interacting with law enforcement in a way that has resulted in this MTRP being filed. I don't know that the
how much time
the competency exam goes into her mental health history rather extensively. She's in a position to kind of maybe indicate to the court why she seems to be triggered by interaction with law enforcement. I would observe too during the incident now that's given rise to the allegations of the MTRP. There was no contraband found in her car. There was really seemed to be no rational explanation for her actions, other than that she has, I don't know, I'm not an expert, but PTSD and a triggering event dealing with law enforcement. I'm not trying to excuse it, just maybe trying to contextualize it, that she could maybe tell the court what was going on in your mind if you had seen interactions with the officer.
No, I blacked out.
She's mumbling. I can't hear you.
I blacked out. I really don't even remember. I'm scared of the police. I'm scared of the police.
Is that the root of your troubles, you think?
I believe it is.
Nobody knows more about you than you. Let me ask you, have you ever been convicted of any other criminal offenses?
Yes.
Yes.
Okay. How many times?
I don't know.
You don't know how many times you've been convicted of a crime?
Twice.
Okay. Is that your?
Violation, twice.
Is it?
DWI,
No, I'm talking about for any misdemeanors or felonies that are above a Class C misdemeanor, above a traffic offense. Crimes.
Probably 5 times.
Sir, ma'am? 5? 6. 6 times.
It's closer.
Well, we're not playing horseshoes. This is real life. You should know better. You should know more about you than, well, I shouldn't have to correct you on that one. This should, but that's 2, 2, 4, 6, 8, actually 9 times. 9 times. 9 convictions. But what's that say? You know, that's from 2011 through 2024, and now this one. You're looking at on a probation. I mean, I stuck my neck out on this one with this criminal history, and it's assault, prohibited weapon, switchblade, and brass knuckle or something. Assault, family violence, resisting arrest, failure to identify, driving while intoxicated, resisting arrest and search. Those are all, they're misdemeanors, but they're still, you were arrested and then you had to serve jail time. You, every one of those were, one was 2 days, one was 9 days, and the rest were 60 days or more. Anyway, that, and you know, evading arrest has consequences because this is, let's see. You have 3 resisting arrest convictions before this one. So, you know, evading or resisting are in the same family. They have consequences. All right. He has 83 days credit here. This is a 3rd-degree felony. So what should we do?
Judge, my suggestion is a 5-year sentence. I think it's warranted by the criminal conduct prior to her being placed on probation. It's additionally warranted because of the offense that was the felony offense that was committed that Your Honor saw the video on. And frankly, I still remember this officer testifying now 2 months ago. He showed great amount of discretion with this individual. He could have charged her with the same offense. She was on probation and chose the misdemeanor offense of fleeing instead. I believe Your Honor even commented on the record about that, just the length of time that went with here and then the number of officers that it took to get her just to comply speaks volumes.
Right.
Then if we go past that, and this year she's had 10 different violations that she's been written up for in the jail that she just doesn't want to follow rules. I don't believe putting her back on probation is going to be beneficial for anybody. Certainly not for Jefferson County. I think the 5 years would be appropriate.
Defense.
Your Honor, I don't disagree with Mr. Ham's characterization of the officer's conduct in this case. I think he showed remarkable discretion both in interacting with the defendant and his choice of charges to file. So certainly I don't take any issue with the officer in this case. He went above and beyond to try to treat her, Ms. Williams, appropriately.
What are you suggesting we do?
Well, without hearing from the probation officer, I don't know if they're willing to continue to supervise her. If there's still a chance that maybe with some sort of mental health intervention, you may be able to mediate the issues that she seems to have occurring with law enforcement. That would be one thing. If the court is inclined to revoke her, I would ask the court to consider taking into consideration mental health issues and consider a lower end of the statutory range.
Anything from probation?
No, sir, we just didn't have a chance to really spend any time with her. I mean, she got on probation in July. She got a new charges in October, but during that time, she never told us anything about any mental health issues.
Yes,
So we'll address that.
Yes, sir. Anything you want to add, man?
I mean, I asked my probation officer, but I was in Houston, so I don't know who I should have talked to. The one in Houston or the one, I mean, it was kind of confused.
She may have been reporting in person here.
Well, the important thing, the first thing you have to do is not commit another crime, which you did twice, along with the other 9 prior convictions. 4 fines that these are new. What are you gonna do with those?
She probably has sufficient time served on.
Which one's Judge?
Misdemeanor.
This, the October 19th.
All right, so I have a felony offense that's pending for the assault on peace officer. And in misdemeanor court, we have the fleeing offense.
Is that where it is?
Yes, sir.
And I will find that if nothing further, there is sufficient evidence supporting this motion to revoke unadjudicated probation if granted by preponderance of the evidence or greater, as the court finds allegations 1 and 2 proven true as the defendant is admitted these violations, and the court earlier in the hearing found them to be proven true not only by preponderance of the evidence, but beyond a reasonable doubt that assault on a public servant and fleeing a public officer criminal violations were committed by the defendant on her probation. Thus, that is a violation of her probation order. Her probation is hereby revoked. Earlier in this case, the defendant had pleaded guilty to the third-degree felony of evading arrest or detention with a motor vehicle voluntarily, knowingly, intelligently. There was sufficient evidence supporting her guilty pleas from State's Exhibit 1. Her guilty plea from State's Exhibit 1 admitted her plea to support her guilty plea to find her guilty beyond a reasonable doubt. I had deferred any finding of guilt at this time. The court is moving forward based on her violations of probation. I now find you guilty beyond a reasonable doubt of that third-degree felony you had pleaded guilty to back in July of last year. And I find you guilty beyond a reasonable doubt. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. You will be given credit for all the time you have served in accordance with this case. Please do that. All of those. Okay. Anything else? That is all.
We may be in the other sense of that vacation.
On who?
On base waves of assault. I'm going to talk to her about that.
What are we doing on Amanda?
She's not here.
I'm gonna call the general election committee for 3 minutes this morning.
Okay. So on Amanda Nolan, we're going to pass on that.
Yes.
Okay. See what you can do on that other.
We'll have
Langston?
We'll have to.
Yes, sir.
Yeah. We only wrote.
Mhm. Yeah, the
1 and 2. And then they're gonna work out the sentence.
right. Well, that's what it sounds like.
Yeah.
This little. Who is
It's not a indicted case, it's the one you.
Oh, this is the one you set the bond
The
on.
bond thing,
Oh.
is there's.
I know about this one.
Yeah,
yes, okay.
you just wanted to go over it like today.
All right. There is a matter that was presented to the court yesterday by the Criminal District Attorney's Office for Jefferson County, Texas. And you are Charles Wilson III?
Yes, sir.
And you were here with Mr. Adams, your attorney, and the state's attorney. The state of Texas filed a notice for a review of a bail decision. You had been placed on $65,000 bond for an aggravated assault and a $15,000 bond for family violence. And the state of Texas, the district attorney's office deems that amount is insufficient under the law to ensure that you will properly appear and answer before the court and to ensure the safety of the community and the safety of the victim. And for those reasons, they ask for a review of this bond decision. And the court has 24 hours to make a decision. And so the court made a decision yesterday because of some emergency matters that prevented all of us from getting together, but I had to make a decision. And this court did make a decision finding this finding this request in good cause, for good cause. And upon reviewing the public safety report, the probable cause affidavit, and the other documentation in this file on these cases, the court raised your bonds to $100,000 in each cases, and also ordered that if you post these bonds, you must remain at home. You would be on home confinement, except for allowing to leave home only for necessities of food, medical care, and meeting with your attorney. And you must travel to and from your house in the most direct route possible. You must have a GPS device if you post these bonds, so that we know where you are at all time, and to ensure that you're not violating these conditions. And also, I think those are the essential features of what the court did. Now, because the rule of law states I have to make a decision, we couldn't get together. I asked you and your attorney in the state to have a hearing today to show cause why, and present any evidence why the court's decision should not be continued and enforced based upon what the court deemed yesterday. And I'm giving the defense an opportunity to be heard and to present any additional evidence you want me to consider. And so I will consider modifying the bond decision if I find good cause from evidence presented. Go ahead.
Yes, Your Honor. Specifically, Judge, under 17.028, it's the state burden to show that the safety of the community and ensure that the safety of the victim of alleged offense warrants this increase or request to review his bond. Your Honor, we ask that the state disclose you what we would believe to be Brady information as it relates to the state's burden as to safety of the community or the safety of the victims. It's my understanding, and I'll ask that the state to disclose, if this is true, that the alleged complainant did not want the bond to be increased, one, and that two, in fact, this Tuesday, she went to the district attorney's office to have the charges dropped. If that is true, and that would be Brady, that would clearly be Brady for purposes of a bond hearing. If she in fact went to the DA's office to have the charges dropped, and if in fact she did not seek to have this bond increased, then on the legal issue of 17.028, safety of the victim, that's clearly Brady, and that would go to that particular, that's my position. My position would be that would be Brady, and I would ask the state to disclose whether in fact.
And how does your client know that she went and did that? I didn't tell anybody because I don't know about that. How did he know? Has he been in contact with the victim, which he's not supposed to be doing?
Well, let's say this. If in fact that is true.
Yeah.
Again, my position.
If y'all want to conduct a hearing on your own, that's fine, but
I think that that's Brady. That's
the court's decision. The court's decision, even though the state of Texas always has the burden of proof in these matters because of the presumption of innocence standard, this court still has its own independent access to the probable cause affidavit and the criminal history, which I am required by law to review in determining bond issues. That's why I made my decision and found that the bond was too low and not appropriate under the circumstances this court reviewed. I'm giving the defense an opportunity to present any evidence you want.
And I have evidence
to that the court will consider in whether it will modify my bond order from yesterday. Go ahead.
Well, Judge, Mr. Laird says that he's unaware of that, but if in fact that is true, our position is that that's Brady and that would go to the safety of the community and the safety of the victim. And I got some more evidence.
Yeah, Brady.
That's Brady in our position.
The experience has been this office has been very sensitive about Brady. We all should be. We all are, and I've not found them to intentionally.
No, I'm not saying he's not.
Brady material. They honor their oath and conduct it responsibly, just as you do in your.
Yes, sir.
Go ahead.
Judge Alvarez asked that, I understand he can't do it now, but at some particular point in time, since he does not know, that he look into whether or not the lady came up with the drop charges and he look into whether or not she did not pursue this. But I got evidence other than that, but that's why I got other evidence.
Okay, that's the court will note that, and it's in the record. But at the end of the day, the decision is in the executive branch of government, not her.
Right.
Somehow, some way, she was a complainant somewhere along the line. And when that happens, then the executive branch of government takes over and does what it does under their responsibilities of the oath that they have taken under the Constitution and the laws of the state of Texas and the United States. So I don't find that they've done anything inappropriate in this case, except follow their oath. And we've had situations where complainants change their mind for whatever reason. The worst thing that can happen, though, is if they decide to change their statements of victimization based upon influence or coercion or even contact on behalf of the defendant, it would be catastrophic for you. Because this court takes no prisoners when that is found to be done. You cannot disrupt what this Constitution stands for and what the laws stand for. And that's what happens sometimes when people behind the scenes try to influence others who are involved in the criminal process improperly. That if that is done, it will be dealt with severely. But nonetheless, I don't have any reason, I don't have any information before me to change what the court's decision was yet. And that's why I'm giving y'all a chance.
And I'm gonna call my client as a witness.
Charles Wilson III?
Yes.
Raise your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right.
Yeah, speak out.
Yes, sir.
Okay.
All right.
Your hand. Thank you.
All right, Mr. Wilson, you understand that I'm not gonna ask you any questions at all about the facts for this particular offense. I'm not asking you nothing but offense. You understand that? Yes, sir. And you understand on our rules of evidence that you testified on a preliminary matter does not subject to the cross-examination for any other issues. The only question that I'm asking you on about is for financial abilities, right?
Before you get through, I don't think that's accurate. I think I can cross-examine him on any issue because part of the rules or part of the reason the judge made his decision was on the safety of the community. So I can talk to him about the offense. So before you put him up there, you better get a ruling.
Judge, I don't think that he's subject to cross-examination. All I'm asking him questions is about his basic income and his ability to afford a $65,000 bond, and asking him about his income has nothing to do with whether or not he committed family violence against this lady. And
I think it does. The issues on bond for the ability to follow the bond conditions and whether his release would be a safety to the community or the victim or others. They can go into those because part of the bond conditions is not to include not to commit first thing, don't commit another offense. But it opens you could possibly open the door for this subject matter to be allowed. Yeah, I got to take a break.
No,
right now. Stand by. I'll be right back. Thank you.
Okay, friends, TCF Live, Super Friday. Got what, about an hour and 20 minutes or so to go? Wahoo, thank you for your $2 super chat. Appreciate that. Wahoo, the newest member to our team of mods, by the way. So, you know, everybody behave yourselves, because I hear Wahoo has a quick trigger finger and you might find yourself in timeout. Oh, golly geez. Where to? Let's go. Allegan County, Michigan, Judge Burnett.
Truancy. I've received information from the attorneys that Ms. Molis is demanding her jury trial, so we will conduct our settlement. First of all, I have reviewed both of these files. I've been involved in them, and it's the court's understanding that at this point in time, we have no loose ends, and we are ready to go to trial on the 2 counts of truancy. The named victims in this case are Layla Molis and Talon Molis. Mr. Villar, from your office, who will be trying this case?
I will, Your Honor.
Okay. And Mr. Villar, do you know if the victims will be present for trial?
I don't think we have brought the victims in. I don't think that would be appropriate, actually, unless the court requires them. We have the school and school liaison officer to testify as to the missing days.
Okay, so you do have your witnesses and you have everyone that you believe would be necessary in order to prove your case?
Yes.
Okay, and they've all been subpoenaed and they're all ready to be here next week?
That is my understanding, Judge. They're ready.
Okay, are there any other witnesses that you intend to call?
No.
Any exhibits that you intend to use for trial?
Yes, we've turned over the exhibits that we intend to use for trial and discovery. They would include, let me see if I can find them all here. We have attendance records, attendance logs. We have attendance contracts. There's 3 separate attendance contracts. Parental behavior letter that we have. So yes, we've turned those all over as well.
Okay. And was an offer of settlement made to Ms. Wolfram on her client's behalf?
Yes, there was. It was an offer that we had hoped would resolve the case, but it was not able to resolve the case.
Would you be willing to tell the court what that offer was?
Yeah, our offer was to allow Ms. Molis to plead no contest to 1 count of truancy. In exchange, we would dismiss a 2nd count of truancy. We would dismiss the case of contributing to delinquency of a minor. And we would dismiss the companion family law case that's going on in the family law court. And they refused to accept that offer.
And Ms. Wolfram, you conveyed that offer to your client?
I did, Your Honor.
Okay, and she is rejecting that.
Yes, unfortunately, Your Honor.
And is there any sort of counter offer that Ms. Molis would be willing to accept?
I suppose if there was further discussion regarding limiting, potentially like a deferred plea or something like that, where, if she completed some version of, community service or something like that, and we were able to, dispense. But I mean, I want to be honest with the court. My client is going to, based on the orders of the other court, have to continue to interact with this school. And obviously the custody case will continue regardless of, all of this. And unfortunately, because of those outstanding issues, that is why I'm very reluctant, and my client is very reluctant to accept offers of, responsibility or liability where she doesn't, fully believe that she has criminal liability because of the continued exposure and the detriment to her children.
So an offer was made for 1 misdemeanor and 3 misdemeanors would be dismissed. Also, a neglect and abuse case would no longer continue to proceed. And she is declining that offer because she has a domestic matter going on, and she would rather have 2 separate trials on 4 misdemeanors, as well as maintaining a case in family court on a neglect and abuse matter. Is that accurate?
No, Your Honor, she doesn't want any of these things, but
I
unfortunately.
understand, but that's the election that she's making.
She wants the opportunity to demonstrate to the court that she is not guilty of criminal behavior, Your Honor.
Okay, Ms. Wolfram, have you received all the exhibits that Mr. Villar has indicated?
I have, yes, I believe so. The attendance contracts and this, I think he called them school reports. I'm not entirely sure, but I did receive all of the information that both Mr. Blair and Mr. Villar have indicated they've sent to me with from the school.
Okay, do you have any witnesses for the defense?
I believe at this point, I had thought that she was going to be part of it, but I think perhaps Deputy Kefauver's testimony will be important regarding the days. And then I may have to call somebody from the school as well, and then Aaron Lord.
And that's in reference to the truancy case, correct?
Yes, because the counselor provided some of the excusal letters, which will be an issue whether it's an issue whether a day is excused or unexcused, and she provided those letters. So I would need her unless Mr. Villar is stipulating, because she did write a letter, so she didn't have contact. If we can stipulate to the letter, I wouldn't need her.
So any of your proposed exhibits, have they been provided to the people?
Yes. No, the letter from Aaron, that would be the letter from Aaron. I also provided homeschool records. And I know we refiled the proof of service on that when the court couldn't locate it the other day. So my client also was homeschooling concurrently. So we provided those records, the excusal letter from Miss Lord from Amplified Life. And then I don't intend to offer it as an exhibit, but I did provide the transcript from the abuse and neglect proceeding where the matter of truancy was already testified to on the record.
Well, I'm sitting here scrolling through trying to find the next thing, and then all of a sudden he cuts his feed. Oh well. All right, let's go back to Judge Stevens. He's back in court. Although he's muted, let's give him a minute, see if he fixes that.
If they're working. Well, we're waiting on that. Let's get to something else.
We can do ours.
Go ahead. Mike's not here. Let's pick up yours. Real quick. What are we doing on?
We have Zion Hartman, Judge.
Okay, what are we gonna do? What are we doing?
She's coming.
Harmon? Yeah. Is he coming back? Mine's real quick. I could be not, I'm super fast. Unless they are gone.
This was a motion to open up the motion.
It's all good, okay? Okay.
Pick that up.
Yeah.
Zion Harmon, 24 CR 83 is called. And there's a motion to revoke unadjudicated probation here. You was here with Mr. West, your attorney and the state's attorney. What do we, you had pleaded true earlier in March, on March 20th. So that's just the other day. Failing to report and failing to turn himself in for state intermediate sanction facility as directed. Anyway, what are we doing?
Your Honor, since then, I believe he has done everything he's supposed to do, but I'll defer to the state on that.
Judge, it's my understanding that it was held in abeyance and he was ordered to go to ISF. And I could defer to probation, but she does say that he has been successful since in completing ISF and since completing ISF.
So what do we do?
If you want to go ahead and dismiss it, because he has been doing well, then we can end.
He's on probation though, right now for 10 years.
Not the
From 24?
Yes, sir.
Okay, so this motion to revoke unadjudicated probation is,
Dismiss. You can-
y'all send me something out?
Yeah.
Yes,
And
sir.
then keep him on probation.
That's all.
Two more. Anywhere that's easy.
On April Francis. Who's here on that from probation? April Francis. It's a review, probation review. Nobody? Nobody at all?
Yeah, she was here just a minute ago, Your Honor.
She was here a minute ago.
She's presumably still on.
Well, who is it?
So
Yeah.
this one.
Okay, when they get here, let me know.
Also,
Then I've got Calvin Walker to deal with, but I'm gonna get this other DeMarcus Maya.
that's Judge.
What are we?
He's the one.
DeMarcus Meyer, what are you doing?
Judge, we're gonna ask that he be released back onto probation.
Uh-oh. Okay, who's here on that?
That's
the state.
You released what? Probation.
No, I think it was me.
Not without a plan.
Mr. Valerius.
I got plans, let him back in probation.
We come home with you.
Sure. I don't
Stay there?
I don't have any. I might even let him use.
Come on up. 234765 is called DeMarcus Meyer. That's you? Is that you, sir?
Correct.
Okay, you were here with your attorney, Mr. Turk and the state's attorney. What are we doing today? There's a first amended motion to revoke unadjudicated probation.
Yes, Judge, my understanding, well, yeah, original one was filed back in.
What are we going to do today?
Asking that he be released back to his probation status.
What we're going to do is know, is he admitting to this or not?
No, Judge.
Then we're having a hearing.
Well, Judge,
We're not going to do anything before we
Judge,
have a
we'll-
hearing.
Yeah, we'll accept for hearing.
We have a hearing.
Yeah, the main thing is he's not following his spindle top plan, and before he's ever released on anything, we need to make sure that he understands to take his medications. If when we get there, when we do the hearing, we'll determine what we're going to do.
Is this boring you, sir?
No, sir. It's,
He's frustrated.
I'm not frustrated at all. I'm prepared for anything that's not coming my way. I'm living by my faith.
Uh-huh. Well, the important thing is you also live by the law as well.
I did. I've been breaking any of these laws.
All right.
That's it here.
You're presumed innocent. Okay, well, all right, what are we gonna do today?
Tap for hearing, Judge.
Judge, I'm gonna have to get his medical records from spinal tap. So
Okay, we're not gonna do it right now.
No, sir.
Y'all aren't ready for a hearing.
No, sir, I need to get.
When
medical-
can you be? Because he's
It's
just sitting
depending
in
on
jail
how
and we don't want.
records, and we're gonna ask for a bond considering he's been largely compliant with his probation.
When can you be ready for a hearing?
I don't have as soon as they can give me medical records, Judge, I can't make.
Here's the problem, is that the bond's gonna be high because he's alleged to not participate, he's not actively participating in treatment at spinal tap, which is a key thing to everything. These are allegations 5 and 6.
Yes, sir. My understanding is the reason that the state filed this is because he was a purpose of interest in a case that has been.
Failed to actively participate in treatment. That allegation is that he didn't go to the treatment.
Did he miss one appointment?
It says on February 4th and February 19th.
Yes.
That's 2 appointments, isn't it?
No, believe me,
Okay.
the next day, Judge, and.
I'm sorry.
Those
Those appointments are important. They're necessary.
I was there today.
Judge, he's been there every day. It's 2 times.
Oh, y'all ready?
Taking his medication.
Okay, Judge.
I've been taking it at the jailhouse.
Okay, there's an issue, a fact issue. When can you be ready on this? What are we doing? Next week? Where are we?
He needs medical records.
We gotta get medical.
How long would it take you to get those? But they're right there, aren't they?
Yes, they are, Judge, but I can't, I mean, I can ask the state to subpoena them to maybe make it faster, but I don't dictate when they give me the
What,
records.
how much time are you asking for?
1 month. It's gonna have to be in late May.
For a hearing?
I leave in 2 weeks. And I will be gone for April.
All right. Okay.
If I can get a faster, I'll let the court know, but I don't know when there was a vicinity. I'm asking that he be able to go back out on probation status and that's.
All right.
He's been largely compliant. He's been in court. He's compliant. with
These allegations are very disturbing. The treatment is, and first of all, it's an assault by.
That was
an
abandoned.
assault. I'm sorry, what?
My understanding is the first and fifth allegations were abandoned. The second and third, possibly the fourth, are the ones that held in
Failing
abeyance
to report.
from 2024.
We failed to report. Failed to immediately report to the probation office's source of income.
And he was since.
Failing to participate
A
in
rehab
treatment
center
of
for
spindle top. Okay, and on the state, who's on this one? Mr. Laird, on this, he's saying that there are 2 of these allegations are to be abandoned. Is that right?
The first and fifth, according to the notes I have and what's been given to me, were abandoned.
That was the previous hearing that we had, because we've had
Is
one
that
where he's
what we're gonna
pled
do?
before, yes.
So 1 and 5 are to be abandoned?
I'm gonna be jeopardy for the same thing.
That's what, there were some notes on, one of the previous hearings that you had where that was true, Judge. No, Mr. Turk showed me those notes earlier.
It's, okay.
So
I have on the original motion, a plea of true to 2 and 3.
right, so 1 and 4 would
And
have been
then-
one, because 5 is the first amended.
Then the first amended rolls around on March 4th.
1 and 4, so
Yes.
5 and 6 are the ones that
5
were
or 6 years last
were
month.
up on this time, Judge.
And 2 times that he's missed out of the weekly attendance.
They're saying that one of those, 5 and 6, one of those doesn't have a basis that he.
Sorry, I
He
may have
didn't-
missed one of the numbers, Judge. It was the first and fourth.
Should have been 1 and 4, because 5 and 6 we just filed, so we couldn't have abandoned those back in the last hearing.
Okay.
That's my mistake, Judge.
Okay.
My mistake.
So he failed to participate in treatment to spindle top on February 4th and February 19th.
Correct, Judge.
How often does he go? Twice?
Follow-ups are supposed to be every 3 months.
Ma'am?
Every 3 months.
I think he goes a day.
What's this? He failed to go on February 4th and then
And
2
then
weeks later.
the 4th was an appointment, and then they rescheduled it to the 19th, and he missed that 19th.
Okay. Okay. Why'd you do that?
I didn't miss it purposely.
Well, I know what happened.
Ubering.
Sir?
I was Ubering and got a Uber.
He wasn't able to make it.
Oh, Uber? What time do you have to be there
Oh,
generally?
is he asking me? Yes.
He's asking you.
That day, I thought it was like, I think maybe 2.
Okay, hold on. Where we,
But the problem is not just dismissing judges. I don't believe he's taking his medications was the main problem. And that's where he starts getting
Nobody
into.
alleged that.
Well, that's part of the treatment plan. It says not following through the spindle toss. Active participate in treatment through spindle toss.
He missed, according to everybody, he's just missed once, right?
Essentially, yes, what, so it's just described.
Well, essentially, it's yes or no, once, right?
He was late apparently, but I think he went back to try to do it the next day.
But it's essential that when he misses those, we know that he's not taking what he's supposed to be doing.
Okay.
Well, part of the reason I want to.
But it says fail to actively participate in the treatment. If it's one time, I mean, if, how long has he been doing this?
He was placed with me back on April the 8th of 2025.
A year?
Yes.
Okay. Okay, how many treatments has he missed?
That,
Just this one?
yes, because their spindle top system did go down because they were hacked. So at one point, they were just trying to get everybody, they kept pushing everybody's appointments back.
Okay. Oh.
So
I don't know what actively participates means. He's also been told by his provider some things too, but I'm trying to verify.
Y'all still want to move forward on the motion?
Yes, sir.
Okay, that's okay. I'm gonna grant him some relief on a bond.
Yes, sir.
But you gotta, I'm gonna let you, I'm gonna release you. Can you pay attention to me, please, sir? You know what it feels like when you don't seem to be interested? And I'm doing my speaking here because I'm gonna make orders of the court that you have to follow, that you're gonna be held in custody if you don't. And I just want to make sure that later on you go, I didn't hear you because I wasn't paying attention. Okay, I'm gonna release you on a personal cognizance bond. You have to follow all terms and conditions of probation, which includes this actively participating in the treatment through spindle top as required. All right, I'm gonna reset this hearing though in 4 weeks. Okay, 4 weeks.
I'll do it when Brett's back.
Okay.
Yeah, and we'll see where we are on all of this. But once again, a failure on probation, your probation can be revoked. You could be found guilty and sentenced up to 10 years in prison. You don't want that, right? I wouldn't. All right, are you gonna follow all the rules? Yes. Thank you.
Okie dokie, friends. Thank you. We made our goal today. Lindsay gets out her competitive streak, $9.99 and $1.99. Ashley, $2. Wahoo, $2. And Great Granny, $2. Thank you, guys. Got us over the goal. So here's how this is going to work on Monday. Going to drop an email in the chat here in a second. yt@courtroomfiles.com. That is the public email address, so anybody out there can use it. This is not just a member-only thing. But I need to get photos from you this weekend. I need them like by late Sunday afternoon, so I have time to put stuff together. Make sure you identify in the email who you are, and if you send me multiple pets, make sure that I know what each pet's name is. Or if you just said one pet, make sure I know what the pet's name is. You can send as many photos as you want, but I need it by like late Sunday afternoon, so I've got time to put stuff together, and I'll put together a slideshow type of thing is what I'm envisioning that I'll run during the 4th hour on Monday. So that's open to anybody out there listening right now, because y'all earned that, and we love our pets here, so let's show them off. Again, yt@courtroomfiles.com, and I'll drop that in the chat. Just send stuff there, and we will share our pets with each other on Monday. Thank you so much, guys. Appreciate it. Let's go back to Judge.
Term of not more than 20 years or less than 2 years in prison. In addition, fine may be assessed not to exceed $10,000. Do you understand? Do you understand?
Yes.
An agreement's been reached. You would be pleading guilty. Sentenced to 4 years in prison to run concurrently with other cases. Is that your understanding?
Yes.
If I follow this, you have no right of appeal. Do you understand? How do you plead to this? How do you plead to this, guilty or not guilty?
It doesn't matter.
Are you pleading guilty voluntarily and because you are guilty? Show you what's marked Exhibit 1 here. Did you sign that voluntarily? Understand it? Discuss it with your attorney. Is everything true and correct? States Exhibit 1 tendered without objection admitted. The state you're mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. If you were guilty of the crime charged in any lesser included offenses and you are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God. Correct? State's Exhibit 1 presented and it is admitted into evidence without objection. Pre-sentence report is away. I will follow this agreement. I'm going to find you pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this offense. I now find you guilty of the second-degree felony of assault on a peace officer. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. In this case, you will be given credit for all time you have served in accordance with this case. Do you understand what has happened today? That is all. Thank you. I have a dismissal on Patrick Pittman. In 26 CR 307, Mr. Ham has presented this on this date. It is signed and granted. Yes, Langston, what are we? Yeah, we're ready. Come on, what are we doing?
I think we're gonna just,
I look back at Rule 104 and if, as long as he sticks to financial, I cannot cross-examine him on the offense unless he talks about the offense or brings
Okay,
it.
so what are we gonna do?
I'm just gonna ask a quick financial question and we can let you make the decision, whatever it's gonna be. It'll be super fast.
And this is. Huh?
This is the state of Texas has requested a review of.
Yes, all right.
All right. Did you hear what I'm not gonna ask you anything about the facts of the case. Don't tell me nothing about the facts of the case, right? You got me? The only thing I'm asking you is a money question. That's it. Got to do with money. Don't let me say nothing about the case. You got me?
Yes, sir.
All right. So you understand that Judge DeRuin, who initially set this bond, I think he said a $65,000 bond and a $15,000 bond, right?
Yes, sir.
All right. So if you go to a bail bonds when they charge you 10%, that'd be 6,500 and then 1,500. It would be a total of $8,000, right?
Yes, sir.
Okay. Right now, do you have $8,000 in any bank account anywhere?
No, sir.
Do you have $8,000 that you could borrow from anybody, anywhere?
No, sir.
Do you have $8,000 worth of property that you could sell and make this bond? $8,000. Do you have that anywhere?
No, sir.
At the time that you went to jail, did you have a minimum wage job working at Church's Fried Chicken?
Yes, sir.
So basically, working at Church's Fried Chicken, minimum job, you would probably qualify for some kind of a federal financial aid or something, right? And then as far as a house, apartment, home, you don't own that, you live with your mama, right?
Yes, sir.
So as far as the bond being sufficient for you being able to appear in court, actually the judge could lower that bond from 65,000 to a lower number because specifically under the rules, when the state of Texas asks for a bond review, and the court pointed out in the prior hearing, the court could actually determine that the existing bond is excessive. So based upon what I read in the court reporter's notes, Judge Stevens can say that $65,000 bond is excessive because of your financial situation. Is that right?
Sir.
So at the end of the day, I told you I wasn't going to ask you anything about the case, right?
Sure.
And I didn't ask you one thing about the case, right?
Sure.
But in terms of MONEY, a $65,000 bond would be excessive for a man who doesn't have a job. He lives with his mama. He has no property that could be sold. And I think, you know, and I let Axford to take judicial notice. I think his age is 23 years old. So a 23-year-old man, no job, no. When I say no job, you can't work at Church's Chicken if you're in jail right now, right?
Yes, sir.
So you done lost the Church's Chicken job, which is a minimum wage job, right? And at Church's Chicken, you basically frying chicken and doing stuff like that. Is that right?
Yes, sir.
So are you asking the court to do what it can do, which is lower the $65,000 bond to, let's say, 10,000? He can lower it. You understand that? Right? All right, that's all I asked, and I told you I wasn't gonna ask nothing about the case.
Anything to say?
Not on the financial, Judge.
I find the, anything else? I find the bond, the setting that the court, made based upon his criminal history and the probable cause affidavit, the circumstances to be fair and appropriate under these circumstances. And I deny the request, and we will set this for,
I don't think it's been indicted though.
yeah, once it, I guess there's an.
It's been received, it's coming up, but very good.
Okay, when the indictment comes, we'll try to get a setting as soon as possible, and then you can resubmit your request.
All right, thank you, Judge.
Thank you. All right, let's go to Calvin Walker. Thank you.
Morning, Judge.
Hello, sir. Thank you for waiting.
Yes, sir.
Mike, I think it's bad.
Why?
Something's on.
Who's here from the state? Anybody? You're Mr. This is a review.
This one comes from where?
Of status. The court has received a report from Ms. Hunter in this case on the status and.
Hey, Judge, can I bring them to the back if you don't mind?
Data phone.
Okay, cool. Thank you, Judge.
A report stating that the defendant has limited income and as of today has paid $13,132.25 to restitution for the Beaumont Independent School Districts, but over $1 million still remains to be paid on this restitution. And I want to ask, how are we doing on trying to raise our monthly installments? Is Mr. Walker able to pay more? While we are awaiting the appeal decision from the appellate court.
Correct.
Go ahead.
Judge, one thing, and I don't know how we're gonna do it, but he has not been credited for those properties, I don't guess, that he signed his deeds for a couple months ago.
Can you go, well, I don't.
But just, I noticed that when I heard that amount, so I raised that. He's got another $1,000 for this month's payment. He recently started working with one of the home contractor insurance companies, and he actually got a couple jobs. I think it was Home Shield, but it might have been the other one we discussed.
Choice Home?
Yes, sir. It was one of those two. I forget which one. But then that's actually been interrupted a little bit. He's had some sort of heart issue going on. I believe Miss Hunter has documentation of his doctor's name and appointments that he's got. They're not sure if it's not a heart attack, but they're basically doing stress tests on his heart and trying to figure out what's going on, which has interrupted the work for a few weeks now.
Is Mr. Walker able to pay more than $1,000 a month? That's
not this month. No, that's for sure.
What about next month?
I couldn't tell you, Judge.
Okay. All right.
I don't want to mislead the court in any way.
As far as your statement, he will be allowed credit for all.
Yes, sir.
It's allowed by law, and those properties, I'm not sure where they are in the process. But the order was met. Those properties are, I think, in the hands of the Beaumont Independent School District to do as they wish, and he would be given credit for fair market value for them.
Okay.
But I'm more concerned.
Judge, fair market value minus what the tax liens were on it, because there was I've been told there was a substantial amount of tax liens that were levied against all the properties.
When we say fair market value, of course, you've got a net on a cost. Somebody's going to have to pay for those, and if it's because of Mr. Walker, then he's not going to get credited for that debt obligation. Somebody else ends up paying on his behalf, not him, but
Can I make I just want to make a brief statement. Whatever it is we discussed 3 months ago, whenever we signed those deeds, that's what credit we would be asking for. And I don't want to get into all of it today because I don't quite frankly remember. But I think just under the notice provisions and everything that we have in our constitutions, whatever it is we discussed, we would just like it applied at some point.
Hold on, but I'm just gonna, this court's, not that this court's spent a lot of research on this, but his indebtedness is not going to be an obligation that the victim should have to endure and pay for. It will be credited on the net amount of the value. That's only, I believe that's just an understanding of just independent fairness. If there were indebtedness, tax obligations, those were his. The victim has already been victimized by Mr. Walker by a jury decision. I'm not going to victimize them again, pay for his indebtedness. That's just a statement. And
right. And I'm trying to preserve, we're in murky waters here, and I'm just trying to preserve that we made an agreement with the court a few months ago, and we're just asking that whatever that agreement was, it's on the record that he get that amount. That's all I'm saying.
I'm like, I wasn't part of that agreement and I didn't want to be, part of it. But when that agreement was said, there was an amount that was represented to the court and the tax liens were not represented to the court.
We didn't represent that. I'm sorry, but we didn't represent an amount. So.
I'm not incurring any ill will on your part. I'm just saying it wasn't.
Okay.
And
that's not an issue that we need to address today, but there's just the victims are not going to be re-victimized.
Oh, I'm fine with that. I'm looking out for Mr. Walker.
Today, what additional information do the parties want to add? And I would like to, where is the appeal status on this? Or is all the briefing done and before the Court of Appeals?
Yes, Judge. So Mr. Nealon submitted his brief, I think, since the last time we were here. And then I don't even think I got an extension. I filed our reply briefing timely. It was a pretty extensive brief from both parties.
So it's in front of the court right now.
Right. We don't have any submission schedule yet, but everything is there for the court at this time, Judge.
Okay. What's they have to say? Anything else you want to add on this?
No, Your Honor.
Because once I'm still concerned whenever Mr. Walker is able to pay a dime more than what he's paying right now, I want to be able to get that accomplished.
Yes, sir.
All right. And the defense right now is submitting that $1,000 as of today is all he can continue to pay per month. Based on days.
He's going to go pay his monthly $1,000 today. He was put back, so he'll be up to date today for that.
All right, that will be done today, sir. All right. What else? Stay.
Nothing for us.
I think we're in recess on this. Thank you, and awaiting an appeal decision.
Thank you, Judge.
Thank you.
Okay, folks, let's go back to Judge Elmore. We got a new contestant there.
Have a seat, Miss Erickson. Miss Erickson is a felony information with 4 counts and some sentencing enhancements. I'm going to go over those. And while I do so, I'll also tell you what I understand to be the terms of your pretrial agreement. Count 1 is a charge of possession of the controlled substance methamphetamine. That's a felony punishable by up to 10 years and or up to $15,000. There's also a second or subsequent drug offender enhancement. That means that if you were found guilty of that offense with the enhancement, the court could increase that punishment within its discretion from up to 10 years to up to 20 years and from up to $15,000 up to $30,000. However, count 1 and its enhancement will be dismissed. Count 2 is a charge of possession of the controlled substance cocaine in an amount less than 25 grams. That's a felony punishable by up to 4 years and or up to $2,000. There's also a second or subsequent drug offender enhancement that could, within the discretion of the court, allow it to increase the maximum punishment from up to 4 years to up to 8 years and from up to $25,000 to up to $50,000. However, I'm told today that if you plead guilty to that count and I accept that plea, the prosecutor will dismiss the enhancement, which means it'll be a felony punishable by up to 4 years and or up to $25,000. Count 3 is a charge of the offense possession of the controlled substance fentanyl. Again, like cocaine, that's a felony punishable by up to 4 years and or up to $25,000. And because of the second or subsequent drug enhancement, that could, within the discretion of the court, allow the court to increase the maximum punishment from up to 4 to up to 8 years, from up to $25,000 up to $15,000 or $50,000. However, if you plead guilty to that count 3 and I accept that plea, the prosecutor will dismiss the enhancement, which means you'll just face the maximum punishment of up to 4 years and or up to $25,000. Then for count 4, this is a charge of maintaining a drug house. That is a high court misdemeanor punishable by up to 2 years and or up to $25,000. Plus, because of the second or subsequent drug enhancement, that could be increased from up to 2 to up to 4 years, and from up to $25,000 to up to $50,000. However, if you enter a plea of guilty to count 4, and I accept that plea, the prosecutor will dismiss the enhancement. Therefore, you'll be sentenced as to a high court misdemeanor punishable by up to 2 years and or up to $2,000. Is that what you understood so far to be the terms of your agreement?
Yes, Your Honor.
All right. I have here presented to me by the attorneys a form, and I'm going to hold it up for you. At the top, it says plea agreement, and this is where they wrote it all out. And on page 2, it appears to have the signatures of the lawyers and your signature. Is that your signature there on the left?
Yes, Your Honor.
And did you go over this pretrial agreement before you signed it?
Yes, Your Honor.
And did you speak to your defense attorney, Mr. Harrison, about it?
Yes.
Did he talk to you about that? Did he talk to you about the evidence against you?
Yes, Your Honor.
And talk about your rights and your choices and the possible consequences of either going to trial, taking a plea or whatever?
Yes, Your Honor.
And my key question here is just to make sure, are you satisfied with his advice and representation at this time?
Yes, Your Honor.
And do you feel right now that at least taking this plea, well, maybe not the greatest thing to do in the world, but is in your best interest?
Yes, Your Honor.
All right. Now, when you put your name or signature on that page 2, did you do so freely, knowingly involved? And did anybody force you to put it on there?
No.
Okay. Now, if you enter a plea of guilty, as we discussed, and I accept that plea, you'll not have a trial. Does that make sense, Ms. Erickson?
Yes, Your Honor.
Now, if you enter that plea, you'll be waiving certain rights that you would otherwise have. Now, these are covered on a piece of paper called an advice of rights, and I'm holding it out for you right now. Is that your signature at the bottom?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And even more importantly, to understand that if you enter a plea of guilty today, and I accept that plea, you will be forever waiving these rights as it applies to this particular case.
Yes, Your Honor.
Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me on the record today. Have there been any other promises, threats, inducements, force, pressure, anything?
No, Your Honor.
Are Are you entering there for the plea of wrongful choice?
Yes, Your Honor.
Now, Mr. Harrison has probably talked to you about potential sentencing. Is that correct?
Yes, Your Honor.
He may have talked to you about something called the sentencing guidelines that only apply to high court misdemeanors and felonies. Did he do that?
Yes, Your Honor.
All right. Now, first of all, I want to make sure you understand that the sentencing guidelines in Michigan are not mandatory, but they are a tool the court must use to help establish a fair, reasonable, proportionate sentence. Has anyone made any promises to you as to exactly what the sentence would be from this court?
No, Your Honor.
Do you have any questions about your rights, the charges, and the plea before I take the plea?
No, Your Honor.
All right. As to count 2, possession of controlled substance cocaine, how do you plead?
Yeah.
As to count 3, possession of the controlled substance fentanyl, how do you plead?
Guilty.
And as to count 4, maintaining a drug house or dwelling, how do you plead?
Guilty.
Before the court can accept those 3 pleas, I need to have you tell me what it is that you did that makes you guilty of those 3 offenses. Turn your attention to February 2nd, in 2026, just a little over a month ago, in Mesick here in Wexford County. What happened? Looks like you actually live in Thompsonville, is that right?
Yeah.
And what happened in Mesick?
Well, I am in the process of moving to Mesick.
Okay.
And I rent a room there with my aunt who has mobility issues, and I'm just trying to get my life together, and I kind of fell off in the last couple months, and I completely understand where I went wrong.
So
And
how'd you get caught with this stuff?
I did sell to an undercover.
All right, so and you gave to this person or delivered to this person some substance. What was that, cocaine?
And fentanyl, Your Honor.
And fentanyl. All right. Now, when you did that, did you know that you had possessed cocaine?
Yes, Your Honor.
Did you also know that the other substance that you possessed was fentanyl?
Yes, Your Honor.
Did you have any lawful prescription to possess that fentanyl?
No, Your Honor.
And did you have any other lawful right to possess the cocaine?
No, Your Honor.
And each you knew what the substances were?
Yes, Your Honor.
Okay. And then so what about this count 4? Did this happen, this delivery or whatever happened at that residence up in Mesick?
Yes, Your Honor.
So in other words, for it to occur there, you also had to store the substances there and then deliver them there. Is that correct?
Yes.
Okay. All right. Ms. Dahl, do you believe the defendant provided the factual basis?
I do, Your Honor.
Are you aware of any of the promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with Scroll 6.302?
Yes, Your Honor.
Mr. Harrison, do you agree?
I do, sir.
All right. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements to support the convictions as to count 2, 3, and 4, for which he is now found guilty. Count 1 and then second or subsequent drug offender enhancements will be dismissed at the time of sentencing. Ms. Erickson, we will be back here in about 4, maybe 5 weeks from this coming Monday. We do sentencings every Monday in this courtroom. Anytime someone's convicted of a felony in a state court here in Michigan, there must be a pre-sentence investigation report prepared by an agent of the Michigan Department of Corrections, which is also a long title for the Probation of Parole Office. This report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide while it's being prepared. And you got to give them one of those folders. Run a score into the guidelines, which again are not mandatory. It will have a recommendation as to the sentence. Please keep in mind it is merely a recommendation, as it is I alone that will determine the sentence. There are 3 steps that involve you in the preparation of this report. Number 1, you're going to get a packet. Samantha's giving it to Deputy Longstreet, and he'll give it to you and you'll fill it out, turn it back in. You want to be as thorough as you can about the contents of that. For instance, people will say, well, I've suffered bipolar disorder or whatever. But I'll look on one of the pages and well, nothing about it. So then I'll go, well, how do you suffer from it if you've never been diagnosed? Blah, blah, blah. So anyways, make sure you're thorough. Next, you'll be subject to an interview with an agent of that office. You have the right to have Mr. Harrison present during that interview. And third, Mr. Harrison will go over the contents of that report with you prior to coming back for sentencing. Each side has the right to come back to the court, request corrections, or make objections to the content and scoring and so forth. Do you have any questions about what we've done today?
No, Your Honor.
Do you have any questions about what's going to happen over the next month while you prepare this packet and all that?
No, Your Honor.
All right. Ms. Dull, anything further?
No, Your Honor.
Mr. Harrison?
I have nothing further, Your Honor. Thank you.
Based upon the fact that the defendant has now been convicted of the 3 felonies, the court revokes bond and remands him to custody of the Wexford County Jail. And we'll see in about 4, maybe 5 weeks at the longest generally. Thank you. We're adjourned.
Okie dokie, friends, it is that time on a Friday where we go to that special little court where justice is done Appalachian style in a dank, dark basement with crimson shining red carpet, lights from the Soviet era, a phone that wants to ring for some reason that I just put on mute, a printer that never stops running the screams of the undead from the background, walls that I swear to God are bleeding, the eternal chair of doom, you name it, it is all there, except for Judge Capper this morning. We have a substitute judge, but be that as it may, we press onward. Ladies and gentlemen, our guilty pleasure, I give you Dungeon Court.
Okay, Judge, this is I believe a informed menacing charge, but there's also a TRC that I wasn't aware of. I got the paper discovery today from the prosecutor. I do need to file formal discovery, get the body cam, dash cam video. If we could come back maybe 3 weeks. I know the bad dates in April are the 20th, 23rd, 27th.
About April 17th.
That would work. Is that good for you?
Yes.
That's fine, Judge.
All right, defendant requests this matter be continued till April 17th for the trial in office.
Motion for disclosure. I get that. Yes, sir.
State of Ohio versus Thomas Mark Baker, case number CRB 25598, CRB 24747. Thomas Mark Baker.
That is one of Mr. Steyer's cases that was on the pretrial docket. I presumptively moved it to April 10th, but I wouldn't know him if I saw him, so I guess he's not here.
Okay. I know you left a copy of the entry with...
Secure, I did, Judge. And the other two that he had for pretrial got their copies and left, but I've not seen this fellow.
Okay.
Possibly hold it to the end of the dock in case he shows up late. I don't know how you want to handle it, but I'll help Mr. Steyer any way I could.
Pass this a little later in the docket.
Okay. And I will look and see if I can't get a contact number, try to tell him to get down here. I'll see what I can do with that.
State of Ohio versus Hunterdale Blythe, case number TRC 26300 A, B, and C.
This is State of Ohio versus Hunter Blythe, TRC 26300 A, B, and C. Mr. Blythe is present this time, Mr. Stratton, 735.
Yes, Your Honor, we pre-tried this. This is a no test. There was I believe, a crash in this incident. We still need we'll probably just set it for another pre-trial. We don't have a resolution of it at the moment.
How about April 17th?
April 17th is fine.
Finish the U.S. Attorney for the April 17th.
Yeah,
Trial
Pre-trial, you said, right?
Pre-trial.
Pre-trial, yeah.
Yeah. pre-trial.
Okay, yeah.
State of Ohio versus Dina Cornwell, case numbers TRC 25-1846 A and B, CRB 25-473, CRB 25-444.
This is the State of Ohio versus Dina Cornwell, TRC 25-1846 A and B, CRB 25-473, CRB 25-444. Ms. Cornwell present for attorney, Mr. Stratton. Matter set for trial.
No, if you go to treat, you get an assessment. You get an assessment. If you don't need it, you just get an assessment. But the results came back in 0.219. So the results come. So, why do you need an assessment? Just assessment for alcohol treatment. Okay. And whatever they involve, whatever they recommend. Okay, you okay with that? Your Honor, we are going to plead no contest to the OVI. We're going to put off sentencing. She's going to get an assessment done and follow the recommendations of the assessment. And go away. Okay. And then, depending on that, that's going to impact sentencing, and also understand the state's going to dismiss the other charges if she does well in that.
That is correct, Your Honor, and we did get the urine results back. The alcohol urine test was 0.219, and also, I hadn't seen this, but we also got the drug urine screen back, and it was 101.82 nanograms per milliliter of THC metabolite. So she had also buprenorphine and gabapentin. So those were the results on that, and we're happy that she's decided she wants to go to treatment, take care of whatever problem she has. She's got the pending endangering charge, which we will hold in abeyance and not go forward with as long as she keeps up with her treatment and does well. And we'll dismiss that at a later time.
And this will also impact what the sentencing recommendation will be.
Certainly.
The better she does, the
And this
less,
is the first offense
yes,
also.
less the sentence will be. So,
Is that correct, Ms. Cornwell?
Yes.
All right, you want to enter a no contest plea?
Yes.
All right, I'll accept your no contest plea. Is there a stipulation to a guilty finding?
yes, we'll waive statement of fact, stipulation of guilt.
Okay, I'll find the parties stipulated to a guilty finding in the matter. Is there someone there that would like to do an assessment on Ms. Cornwell? I see Taylor's got her hand up.
Right here in the black and red.
We don't necessarily need to have her back out after the assessment, because we're not doing sentencing today. So if you need to set that up at a later date, that's fine. So, Mr. Stratton, when would you want to come back?
Your Honor, maybe sometime first part of May, maybe it's best. Any date except May 11th.
How about May the 8th?
May the 8th will work.
Okay. Defendant's request is matter will be set for May the 8th.
Right there in the
That'll be
red.
sentencing
Just leave it right here in black and red. All right, you good?
And pretrial.
Pretrial.
And pre-trial.
Assessment.
Mr. Young. We need to.
State of Ohio versus Crystal Justice, number TRC 26-203, A and B.
Go ahead and have him put on the pretrials. Go ahead and have him called on the pretrials if he's here.
All right, this is State of Ohio versus Crystal Justice, TRC 26-203, A and B. Ms. Justice is here with her attorney, Mr. Stratton.
Oh, there's two copies in here? Okay.
Interveningly, we're going to recall TRC 24-2473 A, B, C, and D, State of Ohio versus Thomas Scarborough, who had previously indicated that there was a $5,000 cashier's bond posted with our court. It was posted in common pleas, and so I'll convert that to a $5,000 OR bond in this matter. Thank you. All right.
Oh, that's fine. We approach her on it.
You may. All right, we're back on the record. 26 TRC 203 A and B, State of Ohio versus Fiscal Justice. Just had a brief bench conference. I believe the state's going to have a motion.
Your Honor, in having reviewed the facts of this case, we were alerted early on that maybe there were some legitimate reasons why the field sobriety test should not be given the weight that they might otherwise. And so we've received some records today that convince us that they probably aren't an accurate assessment of her physical condition at that time as far as impairment. We also had no chemical test, no urine test, no breath test. And there was no erratic driving. The reason for the stop was a headlight out. So under the circumstances, I think it's appropriate for us to dismiss the OVI case if she would plead guilty to the headlight violation, and we would take no position on sanctions on that.
Your Honor, we agree. We'll plead guilty to the headlight charge, and the OVI will be dismissed.
All right. The A case will be nolly at the state's request. On the B case, it'll be a $50 fine and all repaid court costs. There'll be a review hearing set on it for September 25th of this year at 9 a.m. If it's paid off by then, you won't be have to appear. And there'll be no probation.
Hey, you can go over there and talk to me about some agreements and all that now.
We gotta fix it.
State of Ohio versus Repke Testifies, case number CRB 26123.
This is State of Ohio versus Repke Testifies, CRB 26123. There's Testifies here for Mr. Stratton.
Corey Fry is the co-defendant.
Who's the attorney on it?
Mr. Morford.
State of Ohio versus Corey Fry, case number CRB 26122, CRB 24783.
Oh, sorry.
All right, we're also calling co-defendant Corey J. Fry, CRB 26127, and CRB 24783. Both are set as controversial.
No, that's just no. That's fine. Okay. No fines. No be court costs.
I don't know. Community service. Suspended jail. I mean, I'm not gonna be able to get what the normal is. Sure he does. On one more offense, 30 hours. But no, I don't know. I think, I'm not gonna take a position on that.
Okay, all right. So it could be 30 hours. You still okay with it? Your Honor, I think we'll plead guilty to the theft, ask for suspended time, of course. Also ask for no fine or community service. We'll pay the cost. I understand the court does typically do that, but we'll ask for that anyway, so.
All right, Ms. Meisel, is your intention to enter guilty plea to the charge today?
Yes, Your Honor.
All right. I'll accept your guilty plea and I'll enter guilty finding. There'll be a $150 fine. I'll order you to pay the court costs. 10 days jail. I'll suspend all 10 days. To 30 hours community service. Be 2 years level 4 probation. And then order to stay out of all Walmart stores. And as part of your probation, I'm going to order that you get an AOD assessment and follow up with any treatment that is recommended. And we'll need to set that up today. Is there someone who would like to set her up with an assessment today? Okay, see the lady in the back of her hand held up. You're going to need to meet with her and probation before you leave.
Okay.
You're going to have a review hearing, and that's going to be September 25th of 2026 at 9 a.m. If you fail to appear for that, there'll be a warrant issued. If you have everything taken care of and everything's paid off, and your community service is done, and your treatment is completed, if there is any, then that you won't need to appear for that hearing, but otherwise you have to be here at that date and time. Do you understand?
I understand, Your Honor.
Okay.
So still probation. Okay, talk to Mr. Major.
Mr. Major.
Okay, okay, what's your question? All right.
And Mr. Morford?
Judge, I'd like to ask you for a short continuance. We have videos that Mr. Fry wants to come in and watch, and we really need to have a conference outside the time confines of this morning.
How about April 27th, Mr. Morford?
That's good here, Judge.
Defendant's request is a matter of be continued to April 27th. That'll be a pretrial at 10 a.m.
Thank you, sir.
State of Ohio versus Francisco Gonzalez, case number CRB 2697, CRA 26100.
This is State of Ohio versus Francisco Gonzalez, CRA 2697, CRA 26100. Mr. Nash's case now?
Yes, sir.
All right. Mr. Nash is here with his client, set for a trial and preliminary hearing.
Did you say preliminary hearing?
Except there's a CRA 26100 case.
Okay.
That might be the extradition, is that possible?
That is correct, which has been taken care of. We are here today for a pretrial conference through discussions with the state of Ohio. I believe we have an agreement to plead as charged, and then The recommendation from the state of Ohio would be just credit for time served. The defendant is a Georgia resident who has no intention of returning to Ohio.
That's correct, Your Honor. I think you did some time in jail.
Yes, 3 days.
3 days jail?
Yes, sir.
Is that correct, Mr. Gonzalez?
Yes, Your Honor.
What plea was you wishing to enter?
Guilty, Your Honor.
All right, accept your guilty plea and I will guilty finding.
Oh, we also have an order forfeiting the items that were seized.
Oh, we have no claim.
Okay. We'll do I'll do 3 days jail. I'll give him credit for his 3 days on this. And we're just going to complete this case since he's not. So we're going to find court costs on it.
Thank you, Judge.
And we want an order forfeiting the funds that were confiscated.
All right, and any, was it phones?
It was a number of cell phones.
Yes.
Okay.
We have no interest or claim.
Okay. And then there'll be an order that anything seized as a result of this case should be forfeited to the state of Ohio.
Mr. Hilt, what about his personal cell phone?
What do they have?
Well, they took the contraband, which was all brand new ones, but he has a personal that he used, for himself.
Well, I'll tell you what we're going to have to do. We're going to have to call our people and make sure that there's no, I don't think there's going to be a problem with releasing his own phone to him, but we're going to need to make a phone call and find out.
We'll have that back out. We'll have, if you give us just a couple minutes, Mr. Nash.
Okay.
We will have them back out, but typically, absent some compelling reason, his personal cell phone will be released back to him, but we'll give the state an opportunity to check into that.
Which, if we could, I don't know, I mean, we could proceed, and then if there's an entry that we put on later, that's fine.
I don't know.
We were going to go ahead and put the entry on now.
Okay.
On it.
Just see if we can get him on our
Okay.
investigator on the phone.
Okay.
I don't think there's going to be a problem, but
Yeah, just in case.
On the extradition matter, the state's intentions there, I think Mr. Nash indicated it was cleared up, but
we don't take any position on it, Your Honor. If he's
It was I believe it was a warrant out of Georgia on a probation matter, and the probation department's dropped that. And I think all that documentation is in the file.
okay, I see the petition. Yeah. All right, so the extradition matter, CRA 26-100 will be dismissed.
Thank you.
And we'll recall that here in just a few minutes.
Okay.
We've done this,
Thank you, Judge.
State of Ohio versus Justin Brittany, case number CRB 2662. Mr. Morford's case. No, excuse me. No, attorney.
All right, this is State of Ohio versus Justin Brittany, CRB 2662. Mr. Brittany's present. And Mr. Brittany, do you have an opportunity to hire an attorney?
No, sir, I have not.
Okay.
Have you had contact with any attorneys?
I have discussed some options with my sister who's familiar with a couple. And to be honest, my work, I do exteriors of homes. It's kind of weather dependent. And I don't live with my parents or anything. I'm a single income home. I've had some outrageous power bills, and it's just, I'm kind of paycheck to paycheck right now.
Well, now that you've had an opportunity to attempt to hire an attorney and you haven't been able to, I can appoint an attorney to represent you. So I'll appoint Mr. Morford to represent you.
yeah.
Thank you.
All right, well, Mr. Morford, you're just getting involved in the case, so I'm presuming you're going to want an opportunity to file discovery and take a look at those things. Is that correct?
Absolutely, Judge.
All right. Let's do April 17th. That'll be a pre-trial opinion.
Thank you.
State of Ohio versus Kayla Thompson, case number CRB 24792. Kayla Thompson.
Okie dokie, friends, that brings it to an end for today and for the week, but I hope you all had fun. I know I did. It's always an honor to spend my mornings with all of you, so I appreciate it so much. And thank you all for hitting the Super Chat goal today and for all the new memberships that were donated and everything else. Generosity is great. Really appreciate it. And we earned the right to have our pet or plant, if you don't have pets, slideshow during the 4th hour on Mondays. So again, send me your pet photos, yt@courtroomfiles.com. Please do it as soon as you can, because Sunday night will be when I put this together. Make sure that you include your name and the names of your pets or plants or whatever you send me, and we will make sure to show those off in the 4th hour to everybody. So again, thanks so much. I appreciate all of you. Go have yourselves a good rest of your Friday and a good weekend, and I look forward to seeing you all on Monday. Take care. God bless.